are on my list of things to do, so. Sorry. This is how I organize my life. I have a list of things to do. Such Japanese.
So we are ready to go.
Okay, great.
Charlie's supposed
Good
to
evening.
see us? I'm sorry, I just wanted to check and see if you could see us.
Oh, I cannot see you.
Okay, we want to get that sorted out.
I can see the projection.
We're working on it.
Let me bring that camera back up. What's that? That's not what.
Okay, I see Brett now.
Yeah, but that's not what we want. We've got an AV room view up on the.
Well, you know, I do a lot of stuff.
And see the dais now.
You do.
Yep, via the AV room.
Okay.
Okay, so
I think that's what we're after. Yeah.
we're good to go then.
But I believe when it comes time for presentation, it's no longer going to show the dais.
Well, yeah. This computer I'll share the screen and this.
We'll share the
I
screen.
think that should be able to work.
We think we might be able to get it to work. We will
Yeah.
see once we get there.
Yeah.
All right, so then Chair Losfeld, I think we are good to go. I think we're good to start, Chair Losfeld. Did she hear us?
She acting like she can't.
She's acting like
There we
she
go.
can't.
I think that accidentally got muted. Okay, I think we're ready to go.
Okay. Good evening, everybody. I'd like to call the meeting to order and welcome you to the regular meeting of the Milwaukie Planning Commission. Agendas and additional copies of staff reports are available on the city website at www.milwaukeeoregon.gov. You may locate them by navigating to the community calendar where tonight's meeting page is posted. And if you have not reviewed the agenda, please do so. It contains important information about our process. I will start with the land acknowledgement. The city of Milwaukie respectfully acknowledges that our community is located on the ancestral homeland of the Clackamas people. In 1855, the surviving members of the Clackamas signed the Willamette Valley Treaty, also known as the Kalipuya, etc. Treaty, with federal government in good faith. We offer our respect and our gratitude to the indigenous people of this land. On to informational items. Are there any informational items from staff tonight?
Yes. So we have a change on the agenda tonight after meeting with Vice Chair Edge and speaking with Chair Losfeld. We would move the work session item on the downtown design review to September 27th, mostly just because it's a super packed night. We've got a lot on the table. And we want to give Chair Losfeld, who was also on the DLC at the time, at the beginning of this process, time to weigh in on this during a work session before we get to hearing. So we thought that it would be best to move the item to the 27th. So if that's all right with everybody. And then I just wanted to take a moment to introduce Mr. Josh Freeman. So nice to have you here as our newest planning commissioner. So hello, Josh. Welcome to the Milwaukie Planning Commission. We're thrilled to have you here.
Welcome, Josh.
Welcome.
Thank you. Happy to be here.
All right. And I think that's all I have for the moment.
Awesome. Thank you, Laura, and welcome Commissioner Freeman, as we'll refer to you from here on out. Glad you're joining us. All right, audience participation. This is an opportunity to comment on items not on tonight's agenda. Does anyone wish to comment on an item that is not on the agenda? Laura, if you could let me know if there's anybody in the audience.
There is not.
Okay, then I think I will skip through this information. I'll go to the CIAC, which is next on the agenda. At this point in the agenda, the Planning Commission will act as the Community Involvement Advisory Committee. I now ask staff to provide any updates related to the CIAC.
Yes, regarding the CIAC, we've been talking a lot about what the next steps are for the annual meeting and the joint meeting for the Planning Commission and the NDAs. And I have some ideas about that I wanted to talk to you all about. But again, I probably would rather do that for the next meeting, so that since we have so much stuff on our agenda for tonight, if that's all right with you all, just so we'll have a little bit of free board, or we can talk about it tonight at the end of our meeting if we still have time left.
Yep. Doesn't Commissioner Massey have a meeting that is coming up within the next 2 weeks or something?
It's not until September 29th.
Oh, okay.
I've asked Jason about getting a little bit of time, so I will follow up with you.
Is it the 29th? I thought it was.
29th,
Is it?
it is. I double checked because I wanted to make sure that we had time to discuss it a little bit, so it is the 29th, as I understand it. Commissioner Massey is looking at me, questioning me, so maybe I've made a mistake, but I think it's the 29th.
Keep going. Oh,
Okay,
It is the 29th.
okay.
yeah. So
Okay.
nothing else at this time on that, sorry, Chair.
Okay, nope, thank you. Do CIAC members have any items to report? Okay,
Chair?
yes,
Sorry, you may not be able to see me raise my hand, but I have a discussion item that I would like to bring up, which is pertinent to our code amendments for downtown design review. And I am highly disappointed that we do not think that it is important that the NDA land use chairs be able to get to review, especially in the downtown, the playground of Milwaukie. And I did read the objections, and I understand the objections, and I am no legal expert in any means, but maybe we should be taking the opportunity to require that for all NDAs in all neighborhoods, especially for a type 3, and I truly believe especially for a type 1 where they could talk about art installation, which I hope is in that packet as well, and they can talk about color or something like that, or at least be able to preview it. So I hope that this wonderful team that is sitting in front of me here tonight will take the time and actually thoroughly discuss it and really, really think about it and see if we can't come up with an alternative. Thank you, Chair.
city staff, do you have any response or anything you want to add to that conversation?
I think that we can continue this conversation when we have our next meeting on the topic on the 27th.
Okay. Anybody else, any other commissioners want to add any comments to this portion of the agenda? Okay, thank you. I'm going to move in to our first hearing item. First hearing item is lot coverage and setback variance at 2433 Southeast Dove Street. The public hearing on the requested variance at 2433 Southeast Dove Street is called to order. The purpose of this hearing is to consider application number VR-2022-005. The purpose of the application is to request approval from for the lot coverage and setback variance requests at 2433 Southeast Dove Street. The applicant has the burden of proving that the application is consistent with the City of Milwaukee's zoning subdivision ordinance, comprehensive plan, and any applicable municipal code provision, and that the proposal conforms with all of the city's applicable criteria. I now ask that staff cite the zoning ordinance sections where the criteria can be found.
Thank you, Chair. The applicable sections are Milwaukee Municipal Code, Section 19.301, moderate density residential zones, Section 19.502, accessory structures, Section 19.911, variances, and Section 19.1006, Type 3 review.
Thank you very much. All testimony and evidence must be directed towards the applicable substantive criteria. Failure to address a criterion or raise an issue with sufficient detail to allow the Planning Commission an adequate opportunity to respond to each issue precludes appeal of City Council based on that issue. Failure to raise constitutional or other issues related to proposed conditions of approval with sufficient detail to allow a response precludes an action for damages in circuit court. Any party withstanding may appeal the decision of the Planning Commission to the City Council. Persons withstanding are those who have submitted written comments or testify in person or sign the Planning Commission attendance sign-up sheet in our hallway. Conduct of this hearing. If you are here to testify, please remember to confine your remarks to the application and relevant criteria and avoid repetition and not relevant information. If additional documents or evidence are provided by any party, the commission may, if requested, allow a continuance or leave the record open to allow parties a reasonable opportunity to respond. Any such continuance or extension shall be subject to the limitations of the 120-day rule, unless the continuance or extension is requested or agreed to by the applicant. I'll move on to conflicts of interest. Does any member of the Planning Commission wish to abstain from this hearing? Please say something verbally if you're at the dais. Does any member of the Planning Commission wish to declare an actual or potential conflict of interest? Does any member of the Planning Commission wish to report an ex parte contact?
Chair, I would like to report ex parte contact.
Please do.
So about a year and a half ago, Miss Smith came into the Milwaukie Museum. One of the most interesting things about her is that she actually worked for Paw Patrol. So we had a conversation. She came in, she had gotten a letter from the city talking about her property. And she came into the museum looking for some sort of research data to be able to help her out. There were a couple of us in that room. We gave her general guidelines, did not offer any legal advice.
Great. I would also like to declare that I am part of the neighborhood that was notified. This happens to be my neighbor. Although I haven't had any direct conversation with him about this application, I do live next door. I'm aware of what's going on, and just want to put that out there. Okay, I'm going to move on. Will any commissioners who have visited the site prior to this hearing please raise your hand? Thank you. Appreciate those who have had a chance to do that. Did any of those commissioners who visited the site speak to anyone at the site or know anything that is different than what is indicated in the staff report for this application? If so, please say so. Seeing nothing. Does any member of the audience wish to challenge the participation of any member of the Planning Commission? Laura, assuming audience member numbers haven't changed.
No.
Okay, jurisdictional issues. Does any member of the audience wish to challenge the jurisdiction of the Planning Commission to hear this matter? Similarly, Laura, assuming no audience members.
There are audience members here, just to be clear, but they are not objecting to these.
Oh, well, that's important. Okay, well, thank you. I appreciate that. Okay, thank you. Staff report. All right,
All right.
take it away.
I'll try a screen share here. All right, I think we're functioning.
Correct. We see your presentation. Thank you.
Thank you. So, good evening, Commissioners. I'm Brett Kelver. I'm one of the planners with the City of Milwaukee. I'll be walking you through this application tonight. This is application file number VR-2022-005, a variance request for a carport at 2433 Southeast Dove Street. So just a quick overview of the project. I'm kind of showing in the graphic to the left. You can see the subject property is outlined kind of in yellow. It's on the kind of the southeastern edge of the city limits. The site is largely developed with a house and several outbuildings, and the application tonight is for several variances related to a carport structure. This is one where the applicants in their zeal maybe got just a little bit ahead of the process, and we've been working with them kind of retroactively to get the permits and the approvals that were needed for this carport structure. And that involves these variance requests related to the lot coverage for the overall site, also for the rear yard setback for the carport. And along the way, we recognize that due to the height of the structure, it isn't meeting the required minimum roof slope for the type of structure it is. So overall, this is an effort to kind of go back and cross the T's, dot the I's for this project. The subject property is, as many residential properties in the city, recently had its zoning changed. It was originally zoned residential R5, and effective of June this year, like other properties in the R10, R7, and R5 districts, it was actually changed to moderate density residential. As you know, some of the standards, the different development standards for the new RMD zone do relate a little bit more now to the size of the lot. And this is a rather large property. It's 15,000 square feet. And interestingly, our lot coverage maximum allowance goes down the larger the lot size is. So in this case, for what is currently proposed, a final lot coverage of 33% under the previous R5 standards that would have met the standard, but currently that standard has been reduced to 30% for the RMD. The standards that are in play besides the lot coverage are a 20-foot rear yard setback standard and also a 412 minimum roof pitch. So what's being proposed, the graphic to the left, it's oriented with north, kind of pointing to the right-hand side. So Dove Street is on the left-hand side of the graphic. 25th Avenue is along the bottom edge of that graphic. The carport, let me see if I can use my cursor. The carport is this 968 square foot structure off the driveway that comes from 25th Avenue. Part of what's being proposed, so there's new coverage coming in with the carport, but the applicants are also proposing to remove over 1,300 square feet of other covered areas. There's an attached carport along the western side of the property here off the Dove Street side, as well as kind of a outdoor kitchen, barbecue patio area. And those areas are shown in red on the graphic to the right. So interestingly, although we are still talking about a lot coverage variance, the overall site is going to have its lot coverage reduced from its approximately 36% right now. It's actually coming down to 33%. And if this was the only variance that was needed, this one actually falls into the category of one that could be handled with our more administrative type of variance, the type 2 variance. But because the other setback, the setback and the roof, it's coming through the type 3 process. So I think the analysis that was provided, and I've got the approval criteria for both the type 2 kind of variance and also the type 3 variance for your reference. But I'll just go back and say that, as was noted in the staff report, our analysis of this was that, again, overall, the lot coverage percentage is coming down. That would have been able to be handled with an administrative variance. this is a corner lot, which means it has street frontage on two sides. The front yard is on the Dove Street side. That makes 25th Avenue the street side. And what is actually, technically the rear lot line here, it's, again, this would be the northern property line as this graphic is turned sideways. This actually functions a lot as an actual kind of interior lot line. So it's almost like a side yard setback requirement is as or more appropriate than the rear one. And then with respect to the question about the roof slope, interestingly, the style of the house is one that is a kind of a mid-century modern style. We don't have that many of those in Milwaukee, but it's kind of got already more of a flat roof. And so the more flat roof style of the proposed carport actually kind of matches and goes along with the existing house. And so it's more parallel that way. If you have questions about the overall design of the house or other things like that, I'm sure the applicants can give you a little bit more information if you'd like. So with all that in mind, our analysis and assessment of this was that these were all approvable variances. They're ones that I think if we had kind of started all at the same time with this before the project happened, we would be making the same recommendation, I think, to you. So our recommendation as staff is for approval of all three of the variances. I guess I'd ask if you have any questions, if anyone has any questions at this time.
Chair,
Are there any? Yes, please do.
Thank you. Actually, it's probably a question for Justin. And I just wanted to clarify before we get into asking questions of the applicant, perhaps that is it correct to say that the fact that this is a retroactive approval is not relevant to any of our approval criteria?
That's correct. I mean, we're looking at this as if it were an application that's been processed through that. So I think we look at the approval criteria through the lens of whether or not the Planning Commission wishes to grant the variance that they've requested. Staff have provided the analysis that they did. The applicant here is to answer questions. Of course, the impact of not allowing the variance is that the applicant the structures that the applicant has purchased are code violations technically, and so that would have to be dealt with through the code enforcement process if the variances are granted. Does that answer your question?
Yeah, I think so. Just to affirm, there are no approval criteria that are different when it's a retroactive approval.
Correct.
And there are no approval criteria related to, so we shouldn't be asking questions of the applicant about why it's coming later than to construction, for instance, in our questioning, right?
That's correct. There are no enumerated criteria that would address the situation.
All right, thank you for clarifying that. I appreciate it.
Are there any other questions from commissioners at this time?
Chair Losfeld, I have a question for staff.
Please.
Great. So if this had been coming in as kind of a new building application, how would tree code be triggered or not triggered? Looking at the aerial photo, it doesn't look like there's many trees on the subject property. And so I'm wondering whether or not that is something that's in play that we haven't necessarily thought of yet.
Yeah, that's a good question. This is a relatively new part of the code. And I think obviously one question would be, did or would construction of the structure require the removal of any trees? And then I guess we could also take a look to see I think we'd want to confirm that the minimum vegetation standard is being met for the site. And I think there's probably there'd be some sense or correlation of having allowable area on the site for additional tree planting if that was necessary or desired at some point. And in this case, there are no issues with respect to the minimum vegetation requirement. In fact, the work that the applicants are doing as part of the proposal to remove additional coverage does actually free up more space for potential tree planting if that was desired in the future. Thanks.
All right, if that is the last of the questions, I'll ask, have we received any correspondence on this matter other than those included in the meeting packet?
We have not.
Okay, moving on to applicant testimony. Would the applicant or representative like to comment?
Do you want to come up to the table and just state your name and city of residence and
Correct, yep.
have at it?
Hi, I'm Christina Smith, Paw Patrol.
And I'm Kevin.
This is Kevin. And we did actually propose putting in 3 trees. Those were the little red dots on the little map that I turned in. And we were going to put in some cherry blossom trees just to kind of bring in some color.
It's, just so you guys know, it's a 1950 Frank Lloyd Wright plan that the house is built on. And it's the typical Frank Lloyd Wright Harman Kardon built-in sound system, around fireplace in the center, but it's a flat roof and it's all glass. And that's why the carport, to match it, the house is actually a little taller than the carport, but it all matches now with the flat roof.
And the garage is a flat roof.
Yeah.
Because otherwise in Oregon, you definitely would not want a flat roof, but we are the lucky ones. But the solar company that we're going to have some solar installed said we are lucky because it'll accommodate the solar. So we are going to do that.
And it did hold the 5 inches of ice last year.
Yeah. So.
Do you have any questions?
Thank you.
Yeah, thank you for
I
letting us.
would ask if any of the commissioners have any clarifying questions for you. I'm not seeing any hands raised. Thank you both for attending this evening and for providing your testimony. Appreciate it.
Thank you. Thanks, Brett.
Okay. So in terms of audience testimony, do we have anyone who wishes to testify on the application?
I see that we have 4 parties who are in the attendee list for this meeting. I'll ask any of them to maybe use the raise your hand feature if you're wanting to testify about this particular application. We'll give you a few seconds to do that. Okay, I am seeing one hand up for Robert Westcott. I will allow you to talk, Robert. Go ahead.
Yes, Robert, please state your full name and city of residence for the record.
And it looks like you're muted for the moment, Robert. Okay, go ahead, Robert.
Okay. Can you hear me now?
Yes.
Okay. Yeah, I'm just wondering what your perception is of the impact on, myself and our property would be by not accepting this.
Robert, I'm sorry, but I didn't actually catch that you provided a city of residence.
Oh, I'm sorry. It is Milwaukie, Oregon, 97222. I actually live right across the street from Kevin.
Okay. And Robert, I think the request would be that you direct any comments or testimony towards the substantive criteria. Is there anything specifically you would like to question or point out? A broad question that you've posed is not one that we would typically then cover during this portion of testimony.
Well, I'm not real up on all the code numbers and all that, so I really can't do that. But I support his application for this personally, and my wife does too, as property owners right across the street. So I just wanted you guys to know that.
Okay. Great. I'll ask the commissioners if there are any questions for Robert before we let him go. Okay, seeing none. Thank you, Robert. Appreciate your testimony.
Thank you very much. I appreciate that. And I'm trying to figure out why I haven't met you, because if you live right next door to Kevin, but just we haven't bumped into each other, I guess.
Hey, just watch for me and my 3 little kids trailing behind me. We walk around the neighborhood often.
Okay, great.
Thank you, Robert.
All right, thank you guys.
All right. The next portion here then would be related to a rebuttal. I think we had supportive comments there, so I don't think a rebuttal is necessary. At this point, I think we will then be closing the public hearing. The public testimony portion of this hearing on VR-2022-005, 2433 Southeast Dove Street is now closed. I offer the opportunity for discussion amongst the commissioners. Is anyone ready to discuss and would like to start?
I am, Chair.
Yes, go ahead, Commissioner Edge.
Thank you. So this is a really straightforward application, and it is a variance. Obviously, the site coverage is, they're not in compliance with the site coverage. The result of the application is that they are brought into greater compliance, with the standards, and so it's a win. And like the staff report says, is a very straightforward application. It meets all the criteria. I've read the findings and conditions of approval, and I agree that they represent the facts in the record. And I am comfortable with approving this tonight. Thank you.
Thank you, Commissioner Edge. Are there any other commissioners who'd like to comment or offer a motion?
Chair, if I may, I will like to make a motion to approve application VR 2022-005 and adopt the recommended findings and conditions of the approval found in attachments 1 and 2.
I'll second.
It has been moved and seconded. All those in favor, please state aye or raise your hands.
Aye.
Aye. I'm seeing all stating aye. All those opposed, any opposed, please state nay. Seeing none. Okay. All right. So we have a consensus across the commission for approval of VR-2022-005. I will now read the appeal rights. If anyone wishes to appeal the decision of City Council, you must make the application stating the grounds for your appeal within 15 days of the mailing notice of decision. Please see a planning staff for details. We'll now move into phase 3 of the Milwaukie Bay Park improvements. The public hearing on phase 3 of Milwaukie Bay Park improvements is called to order. The purpose of this hearing is to consider application number NR-2022-001, WG-2022-001, VR-2022-006, and DR-2022-001. The purpose of the application is to request approval for the various applications associated with the phase 3 of the Milwaukie Bay Park improvements at 11211 Southeast McLaughlin Boulevard. The applicant has the burden of proving that the application is consistent with the City of Milwaukee's zoning subdivision ordinance, comprehensive plan, and any applicable municipal code provision, and that the proposal conforms to all city applicable criteria. I now ask that staff cite the zoning ordinance section where the criteria can be found.
Milwaukee Municipal Code 19.304 downtown zones, including the open space zone. 19.401 Willamette Greenway, 19.402 natural resources, 19.504 site design, 19.508 downtown building and site design standards, 19.600 parking, 19.700 public facility improvements, 19.911 variances, 19.1006 type 3 review, Municipal Code Title 18 flood hazard regulations, and Title 12 streets, sidewalks, and public places.
Thank you, Vera. All testimony and evidence must be directed toward the applicable substantive criteria. Failure to address a criterion or raise an issue with sufficient detail to allow the Planning Commission an adequate opportunity to respond to each issue precludes appeal to the City Council based on that issue. Failure to raise constitutional or otherwise issues related to the proposed conditions of approval with sufficient detail to allow a response precludes an action for damages in circuit court. Any party withstanding may appeal the decision of the Planning Commission to the City Council. Persons withstanding are those who submit written comments or testify in person or sign the Planning Commission attendance sign-up sheet in our hallway. Conduct of this hearing. If you are here to testify, please remember to confine your remarks to the application and relevant criteria and to avoid repetitive or not relevant information. If additional documents or evidence are provided by any party, the commission may, if requested, allow a continuance or leave the record open to all parties, to the parties reasonable, with a reasonable opportunity to respond. Any such continuance or extension shall be subject to the limitations of the 120-day rule unless the continuance or extension is requested or agreed to by the applicant. Conflicts of interest. Does any member of the Planning Commission wish to abstain from this hearing? Please state so or raise your hand for those online. Seeing none. Does any member of the Planning Commission wish to declare an actual or potential conflict of interest? Please raise your hand or say so. Seeing none. Does any member of the Planning Commission wish to report an ex parte contact? Please state so.
I'll just say really quick that I serve on the Clackamas County Pedestrian and Bikeway Advisory Committee. And in that role, we have been presented to by the applicant for this project in the past. And I have had opportunities in that capacity to offer my opinion and feedback on this application in the past, including this phase of the application. However, I also believe that I am able to objectively review this proposal against the applicable criteria and make a judgment based on the facts and the record.
Thank you, Vice Chair Edge. Will any commissioner who has visited the site prior to this hearing please raise your hand? Okay, thank you all. Do any of the commissioners who have visited the site speak to anyone at the site or know anything that is different than what is indicated in the staff report?
Chair
Losfeld,
moving back to ex parte contacts, like Commissioner Edge, I've also had a variety of conversations with various community members and elected officials about parks and the future of our parks. And Milwaukie Bay has been one of those topics. But like Commissioner Edge, I think I can objectively review the application and make a decision based on the relevant criteria.
Thank you, Commissioner. Anybody else that I might not have seen? Okay, thank you. Assuming then that the response to whether or not anybody noticed anything different from staff report on this application, I heard nothing, but just want to confirm. Okay. Any member of the audience that wishes to challenge the participation of the Planning Commission, please use the raise your hand function.
I see no hands raised, Chair.
Thank you. Jurisdictional issues. Does any member of the audience wish to challenge the jurisdiction of the Planning Commission to hear this matter? Please use the raise your hand function.
No hands are raised, Chair.
Thank you. Let's proceed to the staff report.
All right, see if I can share my screen successfully. Okay. Hope everyone is seeing a presentation. Okay. All right, good evening. Vera Collies, I'm the senior planner here, presenting the Milwaukie Bay Park Phase 3 land use application. All right. I think we're all familiar with where Milwaukie Bay Park is, but just in case you aren't, it is the outlined, the project limits are outlined here in the aqua color, but Milwaukie Bay Park is here on the western edge of downtown, bordered by the Willamette River and McLaughlin Boulevard, and of course, downtown Milwaukee. The park is bordered by open space, residential property, the Kellogg Water Resource Recovery Facility to the south that you can see just outside of the screen, and again, McLaughlin Boulevard. The site is located in the historic Milwaukee neighborhood and is directly adjacent to the Island Station neighborhood as well. The park has a number of zoning layers, as you can see by this very messy map. The entire park site and project area are zoned open space, so downtown open space are within the Willamette Greenway overlay zone. Portions of the park and the project area are also designated as water quality resource area, as well as habitat conservation area. Okay. The proposal includes numerous elements. This is a non-inclusive list of some of the items and some of the elements that are being proposed as part of this phase 3 improvement project. The improvements build on previous site improvements that include a nature-themed children's play area, water feature, additional pathways, another restroom building, public art, numerous plantings, and stormwater management facilities as well. The phase 3 improvements addressed in the application are located within an approximately 3.5 acre portion of the park. Parts of the existing and new permanent alignment of the trolley trail that is part of the park are also located outside of these parcels on 4 segments that are along McLaughlin Boulevard. So there's some trolley trail improvements as part of this as well. And here's some photos that I pulled from the website from the Parks District to show some of the illustrative drawings that show some of the proposed elements for the park. So the application has a few different parts. There is Willamette Greenway review because all of the work is being done within the Willamette Greenway, and that comes with a conditional use review. That's how we review Willamette Greenway applications. There's also natural resources review because of the work that is being done within the mapped resource areas in the park. There's downtown design review that is applicable to the restroom building, and there is a variance being requested regarding the requirement for pervious pavement to be used on walkways. The variance is requesting that impervious pavement be used on the smaller walkways, pathways that are internal to the park, but pervious pavement would continue to be used for the trolley trail as it is constructed today. So it's sort of a limited variance to just the pathways in the interior of the pathways. All right. So staff has posed a few key questions within the staff report for the Planning Commission's discussion. We're asking about the project's impacts on the mapped natural resource areas and have they been adequately evaluated? And do they address those impacts to avoid, minimize, and mitigate those impacts as our natural resources section requires? We're also asking if the proposal addresses the approval criteria for the review of development in the Willamette Greenway. And finally, does the variance request to allow impervious pavement for the pathways, is that variance request appropriate and reasonable, and does it meet the approval criteria for a type 3 variance? I'll walk through these key questions. They're pretty detailed in the staff report and of course in the findings. I'll try to summarize these in a few charts to help with the discussion tonight. So this table talks about the resource areas, the total area within the project limits, plantings, the proposed mitigation, and the proposed disturbance, both temporary and permanent. The Title 4 or Section 402 of the code provides a discretionary process to analyze the impacts, and the application package included a very detailed natural resources report to coincide with the discussion about the impacts and the development that would be happening within those mapped resource areas. And within that report, it talked about the functional vegetated corridor along the Willamette River that contains native trees and shrubs and ground cover, et cetera, and that the vegetation vegetation, however, within the WQR and the HCA that is mapped in sort of the interior part of the park above and east of the Riverside Path is mainly open lawn, as opposed to the habitat that is along the river edge. Other than not building the project at all, there are really no practicable alternatives that could entirely avoid any of the impacts to these map resource areas, because basically the entire park is in the mapped resource areas. The improvements meet a need, and certainly city direction regarding Milwaukie Bay Park and other sites without those mapped resource areas are not an option. They're just not available within the park area. However, the impacts, to the extent that they're able, are being avoided. There are permanent disturbance areas, but the mitigation is well above what is required within the code. It's close to 6 times what is required as far as mitigation plantings, as you can see in the chart here. Okay. These bullet points summarize some of the other aspects of the application that was submitted within the report, talking about balancing the site constraints, public concerns, while certainly retaining the key park elements that are being requested and have been requested as part of this master planning process. The design does avoid and minimize impacts to those ecological functions, certainly along the river, not introducing any new development to that vegetated corridor below the existing paths. So that area that exists with the path that's closest to the Willamette River, that entire area is not being touched by the project. It's everything sort of east of that lower pathway. And all project elements are at or above the level of the existing paths along the river and to the Klein Point overlook. The Willamette Greenway review talks about compatibility with the river, minimal impact on surrounding uses, mitigation of impacts, protection of views, conformance to the comprehensive plan policies as they relate to the Willamette River, landscaping, aesthetic enhancement, open space, and vegetation. The purpose of the Willamette Greenway overlay is to protect, conserve, enhance, and maintain the natural, scenic, historic, economic, and recreational qualities of the river. So there's a lot that's being asked of this overlay. And as I said earlier, the entire property or the entire project area is within that Willamette Greenway overlay. The improvements do enhance features of the Milwaukie Bay Park. That's the purpose of the Phase 3 improvements. And they are certainly, staff believes, to be compatible with the scenic and economic and recreational character of the river. There are numerous drawings within the plan set that talk about how the existing views between the Willamette River and the downtown are going to be maintained. So creating view corridors through the streets, and the way the plantings have been cited to make sure that those views to the river are not blocked. There are key view corridors designed within the application. The development itself has been sited away from the river to accommodate the program park amenities while still balancing those natural resource areas along the edge of the river itself. So based on the criteria for both the Willamette Greenway and the conditional uses in that conditional use review, staff, as cited in the staff report, the project is appropriate. The property is appropriate for the proposed development, and the design does take into account the necessary considerations for development in the Willamette Greenway for the Phase 3 park improvements. And then finally, there is the question about the variance regarding the pervious versus impervious pavement on those interior pathways. And again, not the trolley trail itself. The request is to allow impervious pavement on those interior or those smaller pathways. There was discussion both in the application narrative, but also in the stormwater report that talks about the purpose for the pervious asphalt and the purpose for the impervious pavement, and how the stormwater system, certainly with the vegetative surface facility, the swale for filtration will work and will function very well with the proposed stormwater management on the site. And that the vegetative facilities will provide treatment at a performance level that's similar to permeable pavement. The city engineer did review this variance and frankly had concerns about the request initially, but after having reviewed all the materials, the city engineer is comfortable in recommending approval of the variance for this. And Steve Adams is on the call, so if you have any questions about that, he can certainly answer those for you. The approval criteria for the variance itself talks about the alternatives analysis, avoidance and mitigation of impacts, and then a response to the existing built or natural environment. The stormwater report confirms that the stormwater runoff from the proposed impervious concrete walkways would be captured and will be treated on site through those surface vegetated facilities, those grassy swales. And the applicant argues within that narrative that typical impervious concrete is durable and stable and is less prone to weather-related damage than other degradation than the pervious pavement. Hence the request for that variance for the impervious pavement. And again, staff agrees that allowing those smaller on-site paths is a reasonable request within this application process. We received only the one comment that was in the packet that was from ODOT. Those were comments that were submitted as part of the pre-application conference. And so ODOT asked that we just sort of resubmit those comments, and the applicant is aware of those comments that ODOT submitted. Staff's recommendation is to approve the application package along with the findings, the conditions of approval, and the other requirements. I will note that the attachment 3, the other requirements that was in the packet, had one section within the stormwater portion of number 7 under other engineering requirements. There was one paragraph in there that should be removed. The applicant brought that to our attention. So the final other requirements number 7 will remove one of the paragraphs that was in there. And I'm happy to read that into the record if you'd like that clarification. Okay. The decision-making options are like they always are. You can either approve with modifications. You could certainly continue the hearing, or you could deny the application with findings for denial. The applicant team is here with a presentation as well to answer any questions, but I'm happy to answer any questions from staff as you'd like. Thank you.
Thank you, Vera. Forgive me, I'm just picking up my place here. Are there any commissioners who have questions for staff? I'm not seeing any hands raised. Do we have any additional correspondence or testimony?
We do not.
None. Okay. Assuming we are advancing past the applicant testimony.
I have one question for the staff. Can you direct it to the paragraph that's being removed? Where is that at in the packet?
Oh, yes, of course. So attachment 3 is called other requirements. And under number 7, other engineering requirements, there is the second, hold on. The third paragraph, or the third sort of one sentence paragraph under number 7 says, the stormwater management plan shall demonstrate compliance with water quality standards, or no, sorry, the second one. Stormwater management plan shall demonstrate that the post-development runoff does not exceed pre-development runoff, inclusive of any existing stormwater management facilities serving the development site. That sentence is to be stricken from the other requirements. The applicant raised the question, and the city engineer agrees that that should have been stricken originally. It shouldn't have been included. So that one sentence would be removed from the final decision should you make a decision this evening.
Thank you.
Moving on to audience testimony. Do we have anybody in the audience who wishes to?
Applicant testimony.
Oh, sorry, I just mentioned that. So would the applicant or their representative like to comment?
Yes, the team is coming up, Chair.
Okay, great. Please state your name and city of residence for the record.
My name is Jonathan Bieber, Portland, Oregon.
My name is Heather Cook, Portland, Oregon.
Okay, they have a presentation, Chair, so if you give me 1 second, I'm going to call that up.
And I'm just going to make a quick intro. Again, I'm Heather Cook, and I'm the Planning and Development Manager for NCPRD. And I have with me here tonight Jonathan Beaver, who is our design team principal. They lead the design work for this project along with all the sub-consultants. So he's going to speak to the application and do the presentation.
Great, thank you. First of all, I just want to say that it has been an incredible pleasure to work on this project. This feels like, for a community, a once in a decade or even a once in a generation kind of project. And so we've really treated it with the seriousness that that really requires. I wanted to just maybe talk a little bit about the genesis of this work and then talk a little bit more about the design to give you some insight into how we arrived at the plan that we have today. On the screen is the 2010 master plan, which was really the foundation for a lot of the work that we carried forward. Next slide, please. And in that master plan, it really defines some of the program elements of this park, such as the play area, water feature, open lawn area, and the restroom. Next slide. And subsequent to this master plan, I think there was a lot of community debate about the nature of that plan, and the work that we have done is really building on that. So a lot of the program elements that are in the park today are born out of that, but a few key features have really changed. For example, keeping the large redwood on the site was really important. Developing the plan in a way that felt more naturalistic and compatible with the river environment. Developing the water feature in a way that was more than visual, but something interactive that the community could really engage in. So next image. So I want to just talk a little bit about the timeline. So this is the plan as it is today. Next image. And this work was really, this plan that we developed really came out of a lot of interaction with this community. During 2018 and 2019, we held 3 really heavily attended public events. Next page. Where we developed multiple concepts for the community to review. We got amazing feedback. And really a gratifying experience. And that has really resulted in the plan that you see before you today. Next image. Subsequent to that public outreach, we've been developing the plans. There have been some other subsequent outreach events that took place over the last year. We've been working really closely with city staff and NCPRD to really start to develop the details. And so looking forward, our plan moving forward is to submit for building permits at the end of the year with the hope that we can break ground on the project at the spring of 2023 when the weather dries out. Next image. So I just want to talk a little bit about some of the principles that drove this design, really as a result of hearing from the community, but also paying attention to what the site was really telling us as far as how it should be developed. Next image. Accessibility is a huge issue. This is a steeply sloping site. There's a lot of program on it, and it was really important for us to develop this in a way that allowed all of the elements on the site to be accessible, both from downtown by acknowledging the walkways in the park with the downtown crossings, but also just providing ADA accessibility to all parts of the park. And you can really see the kind of sinuous nature of those pathways that I think reflect the riparian environment. Next image. As Vera mentioned, the view corridors were also really important as we developed this, maintaining views to the park from downtown to really create that strong connection between downtown and the park. But also when you're in the park, capturing the views to the river and maintaining view corridors as we start to revegetate the park environment. Next image. So I'll just talk about a few of the spaces in the park. I think Vera covered this a little bit. Next image. Starting with the interactive water feature. The interactive water feature is a zero depth play space for families. I think this is, this park is really kind of the living room of the community. So we wanted to create spaces that were really family friendly and would invite a lot of interaction. Next image is a view of that space. Next image. We're developing a 3-tiered playground that fits into the natural slope of the environment near the big redwood tree. That'll have some nature play components and a real strong focus on accessibility and making play spaces that are as inclusive as possible. Next image. And this has changed a little bit from this image, but very similar to this. Next. What we would really call the community room of this space is an open lawn area that will serve as an event space for summer concerts or throwing a Frisbee or the winter solstice event with a fire pit. Next image. And this is a view of that from the upper picnicking area. Next image. Vera mentioned the restroom. This is a really important part of the design. There's a companion trellis next to the picnic area. This was cited to be close to some of the family features, the playground, the water feature, but also the trolley trail. Next image. And this was really designed with the downtown design guidelines in mind. We think it is a restroom, but I think it's a really handsome building with board form concrete and wood materials. It does a great job of bringing natural light. We'll bring natural light into the building through a couple of skylights, rain protection on the edge, lighting, drinking fountains. Next image. And of course, the trolley trail, which will be an expanded trail facility. We've been working really closely with ODOT on this. It will widen the pathway to 14 feet and then connecting in on both ends of the park. This will be a multimodal trail that I think will be a great improvement along this edge. Next image. I'll just touch quickly on the natural resource areas. The image at the top shows the outline of the park improvement area with the overlays of the water quality resource and the habitat zone. The image on the bottom shows where the mitigation that Vera mentioned is happening, which is mostly in the north part of the park. That was really designed intentionally as a more naturalistic part of the park, but also there to preserve the views out to the river. Next image. And really, the whole park, with the exception, I guess, of the lawn areas for events, is developed with this native habitat overlay. So we're really trying to connect this park environment with the river and that native riparian habitat, so that those mitigation areas on the north will really blend seamlessly into the remaining parts of the park. Next image. And last is the swale area that's functioning to manage the stormwater on the site. This has multi-functions. It's part of our geese mitigation strategy on the park to keep geese that are walking up from the embankment into the lawn area. But I think it also will provide a really nice educational opportunity and manages all the stormwater runoff from the site. And then last two images really quickly, just give an indication of some of that native vegetation that we're proposing. So shrubs and ground cover and grasses. And the next and last image is related to the tree canopy, which there will be much more of when this project is done. And then with that, I'll conclude.
Thank you very much. Are there any questions from the commissioners?
I have a question, Chair.
Please.
Well, actually, I guess, first, I guess it's really just, I'd like to express my gratitude to the applicant team. I think you've done a really good job over the last few years with your engagement, and I've seen, this project come along and, I'm ultimately really happy. I think with, what you presented, it's really, you've done a really good job with your engagement and evolving this with feedback from the public as that's gone. So thank you for all of that. And then as we embark on questions, I'd just like to again remind the commissioners that we really should focus our questions on the applicable relevant approval criteria and not on other matters that might be of personal interest to members of the commission, but let's just focus on the criteria tonight. Thank you.
Thank you, Vice Chair Edge. While I acknowledge that is not a clarifying question, I do appreciate the message. Are there any clarifying questions from the commissioners to the applicant?
Chair Robert Massey here. I have a question.
Please.
I'm glad to see this. I remember facilitating one of the tables here over at the Masonic Lodge. I guess it was 3 years ago. And so I'm glad to see this come forward. I think that this is going to be a center part of our community. And so I'm glad to see it. I have a question about what I'll call sustainability, survivability. And I would like for the applicant just to clarify to me what I thought I read in that virtually the entire area was inundated in the 1996 flood. Is that true?
Much of it, yes.
So my question is, do you consider, survivability, sustainability of the elements in the design? And would you just care to talk about that?
Sure, and why don't you go ahead and take it?
Okay, yeah.
Anything.
Yeah, no, it's a great question, and it's one that we wrestled with as we developed the design. And as you saw on the plan, there's a lot of program there, and a lot of it is a valuable resource for the community and one that you really want to protect. And there were sort of competing forces here with a lot of that program. On the one hand, the community really wanted to keep some of the elements away from the roadway for obvious reasons, the playgrounds and the water features. On the other hand, we wanted to keep everything up from the flood elevation. And what we've achieved largely is all of those program elements, with the very exception of the lower portion of the playground, are out of the 100-year floodplain. So I think we kind of found the sweet spot on the site that avoids a lot of the impacts for major flooding events. Now, we don't know what the future holds. We don't know what flood events will be in the future. But I think given the site and given the all of the program in there, I think we've done our very best, I think, to keep that as safe as possible in the development.
So what I heard was that it was considered in the design.
Yeah, absolutely.
Yes.
Yeah.
Thank you.
And it is part of the reason you see so much vegetation on so much of the site, because we just have to be very mindful of that, those flood events and how the site can be resilient.
Thank you.
Thank you.
Chair Losfeld, I have a follow-up question to Commissioner Massey's question.
Yes.
I was noticing in the application materials, there was discussion about in doing development in the floodplain, compensatory storage, and it was mentioned there's a 200 cubic yard cut that was occurring. Can you talk about like where within the site that's occurring? And I would also assume that provides some ecological benefits in cases of flood events.
I'm not an expert on river flood dynamics, so I won't pretend to know exactly that, but there is a net cut on the site. That's largely due to the fact that we're trying to get ADA accessible to all of these site elements. And it sort of resulted in that being the case, although I think it's a benefit ultimately to the river environment if there's more storage space. Where that is occurring, it's really kind of across a lot of the site, probably more in the middle to south portion, but I think it's kind of happening across the site.
And I might just add to that, I think part of what, because this is phase 3, the site had already been modified in phases 1 and 2. And historically, I mean, we probably can't even guess at all the modifications over hundreds of years. So I think when we approached this, we were looking at how do we in this phase become stewards not only of this phase, but of the whole project since construction started in 2012 with Client Point, and how do we take advantage of the natural features of the site? So really taking advantage of the fact that we have that high bench, closer to the street, and then the lower areas that are more prone to inundation, that we really maintain that as flood storage, and also, per Commissioner Massey's comments, keep that in I would say, lower investment kind of category where you're worrying about vegetation instead of worrying about, expensive buildings or whatnot. Does that answer your question?
Yeah, that does. I have another question. Since in the presentation, you talked a little bit about some of the public engagement process to date. Could you share with us how stakeholders like the Confederated Tribes of Grand Ronde have been involved as stakeholders in this process?
Yes, I'd love to give you a few examples of some of the different stakeholder groups since 2018. In 2018, we did a round of engagement where we had bike and ped advocates that we met with separately. We had advocates from the communities living with disabilities, really looking at what mattered to them and the people they take care of on the site. We met with Spanish-speaking residents in the district and really tried to reach into some specific communities that maybe hadn't had as much voice in the past, or just haven't in general in planning, and really work to respond to their concerns. In 2018, we did have Confederate Tribes of Grand Ronde Cultural Resources staff come out to the site, tour the site. They were really excited about the possibility of some way engaging with the site, although at that time they weren't really sure what. They thought perhaps maybe the public art would be a good place for them to be involved, but the public art kind of would come a little later. And then since that time in 2020, really this year, 2022, we did do some ongoing follow-up, but mostly in 2022, we circled back during our design development phase, and we again spoke with the bike and ped community. We spoke with Spanish speakers in particular again, and who really expressed their gratitude to us for taking the time to do that. And by that time, the city in particular had developed a really strong, I would say, conversation and relationship with the Confederate Tribes of Grand Ronde. So it was a really good opportunity for them to start engaging with the team on the public art. So I won't go into detail on that tonight, but there is a lot of continued interest and activity with the Confederate Tribes of Grand Ronde working with the city, and by extension with us, NCPRD, on working together on public art on the site. So it's been extensive and actually pretty rewarding, because I feel like we've been able to respond a lot to that community input.
Thank you.
You're welcome.
I have a question, Chair.
Please.
I guess this is more about utilities and the utilities that would be used on the site, and how they interfere with the, especially with the water quality rezone. I am assuming that there are going to be electric plugs down there by the amphitheater, right? To be able to use, and how are those, is there a shutoff valve higher up? Is there, how do we know that that is not going to cause a hazard when when it gets into that water quality resource area?
Are you referring to the potential flood event?
Yeah, if a potential flood event comes, a high wake, whatever could cross over the top of that.
I see. Well, we're way beyond any high wake sort of impacts at the stage area, which is where the electrical outlets are. Our team has been debating the configuration of those outlets in recent meetings. So we're still working on some of the details. No doubt during a 100-year flood event would be underwater. There is all of the source power for the park is up at the restroom, which is well out of the floodplain. So all of those services can be easily disconnected or, breakers disconnecting that water. So, and we're really only talking about, 110 outlets for, music events and things like that. So I don't think it's a huge concern, but obviously any flood is going to pose issues for the park.
So, and then a follow-up or a new question, I guess, if I may, Chair. Why did the amphitheater move? So I've been around long enough that I remember the 2000 master plan, which had all of these same kind of features in it. And so that amphitheater had been sitting in that same spot where it was in 2000, where it was in 2010. Why was the decision made to move it closer down to the river and not leave it a little bit higher up on the hill?
You want me to start that?
Yeah, go for it. Yeah.
So we actually proposed a number of different configurations with the community. We had the community weigh in on sort of the broader principles, and then from that, Inc. led the charge on developing 3 designs for alternatives, and we got community input. And in addition, during that whole time, we were weighing this sort of question of where do we put the amenities that require, more infrastructure. And so what kind of naturally happened is that amphitheater both was a public, I would say, preference to have it in the area it is now, but it also kind of moved down the hill when it became apparent that we really needed to be aware of flood concerns when we were putting in a restroom or putting in a playground or putting in an interactive water feature. So by the time we kind of pull all that stuff up on the bank, the real opportunity area for the amphitheater was down in the lower, what I would call more the basin of the site. And do you have anything to add to that? I feel like that's sort of the evolution over time of that scenario.
Okay.
Okay. Are there any further questions? I'd like to move on then. Thank you both for your testimony. I appreciate it. And thank you for sharing your time this evening. Do we have anybody in the audience who wishes to testify on the application? If so, please use the raise your hand feature in Zoom or...
Chair, we do have someone here in the audience who has submitted a speaker registration card. Gary Klein is here to testify.
Great. Gary, please state your full name and your city of residence for the record.
Gary Klein, 10795 Southeast Riverway Lane, Milwaukie, Oregon, 972227422. I live right next to the park. I've lived in that area most of my 75 years. I moved here in 1948, graduated from Milwaukie High School, veteran, retired banker. I've been on the Riverfront Board. Then that changed to Riverfront Task Force, of which I was vice chair. And from there, I moved on to Milwaukee's Park and Recreation Board. I've been in that position now for over 4 years. very pro the park. I've been working on it for years. If you check back on records, there's been recommendations and things involved on that area for a park for well over 60, 70 years. Anyhow, I think Heather has done a great job, outstanding in promoting and pushing for phase 3 of the park. We've done phase 1, Klein Point, and we've done phase 2, the new boat launch and the different paths and so on in the park, and we're all ready for phase 3. We did phase 1 and 2 pretty much on Milwaukie funded and grants that we got, and now we're trying to step into phase 3 to get the park pretty much done. If you have any questions, I've been following this for a long time, as you can see. I'd be happy to answer any, and that's about it.
Thank you very much. I'll ask the commissioners if there are any questions that you might have. Seeing that there are none, I want to thank you for your commitment to this park and your service to the city of Milwaukee. I appreciate you being here tonight, and thank you very much.
Welcome.
Chair, I don't see anyone else in the audience wishing to testify, and there are no hands raised in Zoom either.
Okay, the applicant has an opportunity for a rebuttal. I'm assuming there is no rebuttal.
I see no interest in a rebuttal from the applicant.
Smart. All right. Then what I'll do is I will close the public hearing. The public testimony portion of this hearing on NR-2022-001, 11211 Southeast McLaughlin Boulevard is now closed. This is our opportunity to discuss amongst the commissioners. Who would like to lead? Vice Chair Edge.
Thank you, Chair. So this is, this is the culmination of a really years-long effort, obviously, and and so the programming and the layout of the park is pretty much finalized. It's really just up to us to decide if it meets the criteria that's before us, and there's a lot of applications here. There's a lot of things to review and approve. I've gone over the findings and conditions of approval with the amendment to the additional conditions that Vera mentioned at the beginning. I think that that reflects facts in the record, and it's consistent with the applicable criteria. And in spite of its complexity and the fact that we could spend many hours going over the criteria and how it complies, I think it does, and I'm confident that it does. And I'm happy to approve this tonight.
Thank you, Vice Chair. Other commissioners with comments? I'm seeing no hands raised. Would anyone like to entertain a motion?
Maybe I'll just, a few comments before maybe a motion gets kind of put on the floor. I agree. I think it's fairly clear that most of the substantive criteria are met. I could hear some frustration in Mr. Klein's voice. And I'm reminded for my fellow commissioners, if you have not read it yet, City Manager Ober's memo, August 5th memo to City Council, I would recommend you take some time and review those materials, which talk about how long this process has been going on and how costs have been increasing and how community members like Mr. Klein and probably dozens of others have spent many years talking about this as Commissioner Hemer shakes his head. So I'm excited that we're at this moment, but in some ways this moment probably should have came many years back.
Thank you, Commissioner. Are there others who'd like to add?
I'll just add this. I have known Mr. Klein for a very long time, and I didn't think that he was going to be alive to see phase 3 get put through. So congratulations, Mr. Klein. Oh, if the funding comes through. So I will, I'm not prepared to make the motion. I'm on the wrong page.
Is there a commissioner who is prepared to make the motion? Thank you.
I'll offer the motion. I move that we approve application NR-2022-001 with the findings and conditions of approval as amended by staff.
I second the motion.
It has been moved and seconded. All those in favor, please state aye
Aye.
Aye.
or raise your hand. I'm seeing a unanimous vote of approval for proposal NR-2022-001 approved by this commission. And I will now read the appeal rights. If anyone wishes to appeal the decision of the city council, you must make application stating grounds for your appeal within 15 days of the mailing of notice of decision. Please see planning staff for details. Thank you, everybody who participated, and really excited to see this moving forward. All right, commissioners, now we're moving into the work session items. I was going to suggest maybe a 4-minute break.
Great. That would be wonderful.
Oh, it's 3 minutes now. Let's just say 5 minutes. We'll start at 8:02 on my clock. Is that all right?
Some of us can't run down the stairs.
The stairs.
8:02.
3 minutes and 37 seconds. be snow. I did.
Well, it's glaciated in the winter, and parts of it are glaciated.
Chair, we are on the air whenever you're ready.
Encounter some snow and ice. 99 steps.
Yep.
Listfeld, we are on the air. Can you hear us, Chair Listfeld?
She has her headphones still plugged in.
Now I can.
We're on the air. We're ready.
Laura, did you hear me earlier talking to you and respond back?
Which earlier?
At like 8 o'clock, I was calling your name. Okay, apparently not. Makes a lot of sense now. Let's see. So now we're going to get into the work sessions. I have first on here downtown design review, which we've discussed. We'll be moving to a future meeting date. So I will skip down then to code amendments, high density zone definitions. The work session item is a discussion of code amendments related to the high density zones. Senior Planner Vera Coles and Associate Planner Adam Haru, I hope I said that right, will present the information about the code amendments for discussion.
Okay, thanks everyone. Part 3 in our 3-part series about high density residential zones. I will be using a PowerPoint to work our way through this as well. Okay. Right. Okay. All right. So as I said, this is our 3rd work session related to redefining allowed uses and working on consolidation of our high density residential zones. So as a reminder from, I think, 2 sessions ago, we originally had planned to consolidate the high density residential zones during phase 1 of our comp plan implementation. That was all the middle housing code work that we did. But it was pretty complicated. There are some things that, that came to light that the consolidation of those high density zones was not going to be possible at the same time as we were doing the middle housing work. So we kicked it to its own separate project, which is where we are now. So we've been working with you folks on trying to refine this potential consolidation, looking at definitions. We're going to be looking at some of the land use review processes as well as part of this process. So that, and this is all in anticipation of a first public hearing on September 27th for the high density residential zones work. But the map you see in front of you here shows, in particular, it's all of our zones, but what we're calling out specifically are our existing high density residential zones. We have 5 of them, R3, R2.5, R2, R1, and the R1B. And this map shows where those are with all of the other zones grayed out. So you can see that it's not very much of the city, to be fair. It's a small portion, but you can see that these are where we've isolated those high density zones. So you can see where they are throughout the city. They're generally concentrated around downtown, a bit around the Providence Hospital sort of area, and then a bit around the King Road Shopping Center where the Safeway is. Okay. So we've had, as I said, 2 previous work sessions talking about consolidating definitions, particularly around our residential care facilities. Our last work session, we talked about boarding houses, single room occupancy, and that sort of thing. So we wanted to kind of get some clarification there. And I'll be talking about that as part of this presentation too, because we've sort of gone back a little bit after we did all of that work on the boarding house definitions. Tonight, I want to talk about the uses, the review processes, and the actual consolidation of the zones themselves. Again, working on having a public hearing on the 27th, where hopefully we'll get a recommendation to council, and then we'll start the city council review process on October 18th with a work session with a planned or hopeful hearing date on December 6th. Okay. I'm going to start a little bit with some of our previous Planning Commission discussions. And at the last meeting, we talked about sort of the history of and kind of some of the baggage that comes with boarding house uses, single room occupancy, et cetera. And at that time, we were proposing to go with a more neutral term of micro-unit housing was what we wanted to call it, and sort of get away from what we thought were pretty loaded terms with some negative connotations from history regarding the terms boarding houses and single room occupancy. However, micro-unit housing has been used as a descriptor for just really small apartments. So that have kitchens and everything. And that's not what we're getting at when we're talking about these types of housing situations or group housing situations. We're talking about rooms where there aren't kitchens, where they're communal kitchens, and they're shared as part of that development. And so, and then we were also, and I thank Vice Chair Edge for reminding us that single room occupancy is also a sort of is a term used in our transportation planning rule in the state as well. So it's an understood term. It's something that folks know what that is. And so we are proposing to actually kind of go back to using single room occupancy, or proposing that single room occupancy be the name or be the term that we're using for this type of housing. We haven't made any other changes as far as the proposed definition, but we wanted to go back to single room occupancy as opposed to the micro unit housing to reduce confusion and make sure we're all saying the same thing. So I'm going to pause here and see if there are any questions about that, or is there general support from the commission to use this as our terminology for this type of group housing situation?
Yeah, I like the addition of the 5 or more, because remember the original definition, I said, hey, what's this between somebody renting a couple rooms inside their house? And so that is a very large house if they're renting out 5 or more rooms. So I do like it, and I like that it's the monthly and longer basis. That way you don't confuse it with a hotel room.
Correct. Yep.
So I think the definition is great.
Yeah, I would second those comments. I was glad to see that clarified here.
Thank you. If I might, I wanted to jump in, and this was something that we did talk about at the last meeting, and thank you for bringing it up, Commissioner Hemer, was the idea of making sure that this is a residential use as opposed to a commercial use, which is what the hotel motel is. And so we wanted to make sure that that was very clear in making that distinction. So glad that's working. Okay. All right. There was a question from Vice Chair Edge about an eco-housing development in Portland, and I confirmed with him via email that the Pearl Studios development is what he was talking about, and those are in fact, well, they are micro units, I guess the way they're actually being called. They're really small apartments. They have full kitchens. They're sort of perfect for an IKEA type situation where everything is sort of stacked and inside everything. But we would consider that multi-unit housing as part of sort of the way our code would define that. I think Vice Chair Edge mentioned that there might be some of the units aren't full dwellings. And so I think we would still be thinking about that as some kind of a combination of multi-unit housing and I guess some SRO as well. I think it would depend on where they were being proposed. But I just wanted to clarify that we did look into it, and it looked like that the majority of those units are in fact just really small apartments with full kitchens. Okay. And there was a question about how different are what we're now calling SROs from transitional facilities or shelters or that sort of thing. And so what we wanted to do was take some of the I guess the vagueness of the description of what a temporary or transitional facility is, and we would remove the may. And so they provide temporary transitional services to families or individuals. Average stay is 60 days or less. It really is intended to be, it's not permanent housing. And that they do, and they are, shelters and community counseling centers and rehab centers and that sort of thing. So just trying to remove some of the ambiguity from the definition. And this is our existing definition, but what we wanted to propose was take the may out of the definition to try to provide some more clarification there. So I think Commissioner Hemer, I think you had brought that question up. Does this satisfy, does that cover that?
No, that makes totally amount of sense that that there are two separations of the idea, and it's, the 60 day or less, which is really kind of what the, what the difference is. And it doesn't define how many rooms it has to be and that kind of stuff. So, yeah, I just wonder, the may includes, I kind of actually like, because you're not just giving a list of what they can be, right? So includes or includes, but not, I don't know. I think the may includes at the end of that may not be a bad idea to keep.
We'll take another look at that.
Because it could be almost anything. I mean, really, it could be a, it could be tiny houses or something like that, or it could be even a hostel or, whatever you want to consider. I dream big. Big tourism in this town.
The second may might be the one that you want to keep, whereas the first one might make sense to strike.
The first one you don't want.
Got it. Good. No, that's great feedback. Thank you. Okay. Okay, now we're on to the new stuff that we haven't talked about yet. All right. One of the things that, as part of the consolidation, when we were working through this, and this is something that happens every time we talk about it, we open up the code, we start finding other things. But this was something that did come up because right now in our code, there are multiple different ways that the term office is used. And this came up because the R1B does allow offices, but in our downtown zone and in our NMIA zone, we've created 3 office types. So some of our zones have multiple kinds of offices and other ones don't. And that is messy and we don't like that. We would really like them to all be consistent across the code. So we used this, the door was opened because of the office uses that are permitted in the R1B. So we decided that we would walk through that door and try to consolidate those office definitions and clean it up. So we're going from 3 office types down to 2. Because when we read through the definitions, there really didn't seem to be enough difference between the traditional office and the professional and administrative office. So the idea was to combine those, maintain the production-related office. We understand the purpose of that, what it is, and it's being used more specifically in the downtown. Kind of where this all started was the idea of trying to understand which types of office still engage with the street and which ones don't. And so that's where this kind of these differences were drawn, or these lines were drawn between these types of offices. So our proposal is to, again, keep the production-related office type, but combine the other 2 and just have the 2, and then make those changes consistent throughout the code. So that they would be permitted and again, the difference really mattered in the downtown. That was where the distinction was made through the Moving Forward Milwaukie process. Again, that idea of production-related office where the doors are basically shut all the time. There is no interaction with the street. Folks, the general public are almost never going in and out. And so there are areas of the downtown area where those types of offices cannot be on the first floor. Because they take up really valuable storefront space. And so that's not a distinction that's made in our other zones necessarily. But so we want to certainly maintain that for its purposes within the downtown, but just combine the other 2 for clarity. There just isn't enough difference between the other 2. We didn't think. So, hoping that is, I'm hoping I made that clear what we tried to do, and I'm wondering if folks have any questions or issues with kind of trying to make those clarifications throughout the code.
A clarification question. So functionally, what I was trying to understand is how are these different types of offices applied? And I think what I'm hearing you say is that in the DMU zone, there are some places where production-related offices aren't allowed on the first floor, and that's the functional difference between these different office types. Okay, great.
That's right.
That was the one, like, my major contextual question as I was kind of thinking about this. I have some additional maybe thoughts, but I'll open it up to others first if they have any other questions.
So I get confused because I don't know how a dentist does not create foot traffic or face-to-face customer contact.
They do. They do.
Well, that's what I think that they do.
Yes.
I understand, I get the point of why the two differences are there, but is there a way to maybe combine in a little bit of expected customer interaction or something like that with the professional and administrative office? So in other words, production related is you don't ever expect to have anybody walk into your door. A professional and administrative office, typically somebody may walk into the door, right? And that's the two differences between the two. So I think maybe adding that into the definition of professional and administrative, which it doesn't necessarily say, but it certainly says that in the traditional office.
If I may, I think that what we were looking to change, so the way the professional administrative office, the definition reads, the second sentence reads, these office uses generally involve a high level of face-to-face customer contact and are typically expected to generate foot traffic.
Oh, am I on the wrong page?
No, you're not. I'm looking at sort of what we were proposing in the code. So that sentence, we would like to insert that sentence.
Okay, perfect. Thank you.
Into that.
Thank
Does that
you.
work?
I apologize.
No, not at all. That's great.
No, you were just ahead of it. You
Yeah.
knew intuitively that needed to happen.
Yep.
Don't butter me up.
Personally, I think I'm fine with consolidating. I would maybe be interested in opening up a discussion on what fits in production-related office. I think something like software and internet content development and publishing generates foot traffic. Knowing that these kinds of companies have clients that they meet with, maybe not all the time in person because of our current COVID environment, and also just hearing that broader context about some production-related offices not being allowed in the downtown zone. I think many downtown businesses and retailers would probably love to have software and internet company located there, eating lunch there, getting their hair cut there, and those kinds of things. And so I think that something like that one specifically also kind of fits within the professional administrative office definition. But I just wanted to throw that out there for you all to think about.
If I could, through the chair, so production-related offices are allowed in the downtown.
Oh.
They're just not allowed on the first floor in certain areas because of that kind of lack of foot traffic. So they're allowed on upper floors, but just not on the first floor.
Thank you.
Yeah. Mm-hmm.
Sensing that we're good.
So I would like to clarify. I would like to clarify with Vera. So we're right now discussing consolidating the office definitions, or consolidating from 3 to 2 at least, and then we're not really at this point talking about. I keep hearing you refer to the NMIA and the DMU, but what about R1B?
Right.
Was where this office is a primary permitted use. What impact does this have on R1B? Or are we not there yet?
No, it's a great question. Thank you. And the reason I brought up the DMU and the NMIA is because those are the only two zones where we have production-related office, as an example of a type of office. These distinctions were only made in those two sort of newest kinds of zones. And so so the proposal for the other zones that allow offices is to allow both types of offices. And so the code amendment for the R1B, for example, would say office, production-related, and professional and administrative, and it would allow both. So we would maintain the distinctions as they exist in those two, in the DMU and the NMIA, and just put the both of the office types in all of the other places where offices are permitted, so that we're kind of consistent.
Okay, thank you. That is what I missed, yeah. Thank you.
Okay. All right, I'm good.
Are there other commissioners with questions or comments for Vera? Okay. Vera?
Okay, thank you. You know I'm not happy if I'm not talking about code. So I'm so glad this came back up. Okay. So this table, and again, this was in the staff report as well, talks about what the following tables, I'm showing sort of a progression of the proposed consolidation of the zones themselves. Again, we've got 5, we're trying to have fewer. And so this first table shows our existing 5 zones, but now we're talking about sort of these new uses that we've been talking about. I know this still says micro unit development, but I just wanted to I didn't know if we were going to be okay with SRO yet, so that would be SRO. The residential care facility, that's the new uses that we talked about in our first work session, as a residential care facility as sort of an umbrella use term for assisted living, nursing facilities, memory care communities. So that's that term. So just kind of wanted to show you what the existing zones look like with some of these new uses inserted. And now the proposed consolidation is that the new R3 zone is the existing R3 plus I think there are 4 or 5 lots that are R2.5. So that's the new R3. The new R2 is R2 plus R1, and we would keep the R1B as it is. Because of those permitted outright commercial uses in the R1B, we thought that made sense to maintain that as its own zone and sort of clean up the other ones this way. So the key differences here, in our commercial uses, you'll see the proposal for the office discussion as I talked about. We are also proposing, we'd like to add personal and business services like salons and nail salons and those kinds of personal business services. We get requests a lot for those kinds of things to be allowed. And we try to figure out a way that, well, is it kind of like a clinic? Because a clinic is technically an office. So this seemed like a decent opportunity to kind of open that a little bit up and allow for things like a salon or that type of use within those commercial use categories. So maybe I'll pause on here for a second. To talk about sort of the proposed consolidation. There's a little more to talk about as far as how the zones flesh out and sort of geographically. But I did want to ask about this idea of allowing the personal and business services, if that sounds palatable, to allow those kinds of uses where we're already allowing offices as well. Does that sound reasonable to folks?
I've got a
I would say so.
Yeah, I would agree.
I can jump in really quick. I think that sounds reasonable. I guess, let me refine my question. Go ahead if someone else has another question. Let me think about it for a second.
I have a problem with making it a conditional use in R3 and R2. Why don't we just permit it outright? I mean, when you look at the map, so it's not that I don't appreciate Jacob Sherman, but we don't really lean next to each other very often. So, but I'm looking at his map, and when I look at the R3 and the R2.5s and all that, they're all clustered around these big areas anyways. And so if somebody wanted to put a hair salon outside of their house or in their house, or use, a house as a business, it seems like to me, even if it's a lawyer or if it's somebody that creates websites, whatever. I mean, it just makes sense that they're not. The reason why you wouldn't want to do it is to say, oh, well, they're going to cause too much traffic, but they're not causing a bunch of traffic. You know, it's kind of a one-on-one personal service as it is anyways. That's my feeling, I guess.
I think I'm getting around to my question. These are all multifamily, or I know we're not using multifamily. These are all multi-unit residential districts, right?
Correct.
Although I see single detached dwelling as a primary permitted use in each.
Yes, they're still permitted. But if I may, just to clarify in your question, Vice Chair Edge, multi-unit development is highlighted here as a permitted because multi-unit development right now is a conditional use in the R3 zone.
Yeah.
And as part of this consolidation, we are proposing that it be permitted outright. Similarly,
right, yeah.
Residential care facility, which we would consider it's still a residential care facility, but it's kind of like a multi-unit development as well. Those two uses, as part of the consolidation, we would propose that they be allowed outright because they are permitted outright in the R2, in the other zones. The R3 is the one that has some extra process for some of these uses.
Right. So I guess it would be helpful for me to see the map again of these zones and where they're clustered.
It is very helpful.
So this map is a map of the proposed consolidation of gluing them together.
Can you show the entire zoning map? Yep. I think it's a little bit easier to grasp.
If I may.
That way.
So excuse the flipping of slides while I get to it. This one?
No, the full one. There you go.
So you can see the R1B and the R2 are generally around the downtown. There is a small section of R3 and R1 sort of just south of that, sort of in that Island Station, Lake Road area. R3 is predominantly Providence Hospital, that area. And then the R3, R2.5 is around the King Road Shopping Center. There are a couple other pockets, but those are sort of the main ones.
Well, I'm kind of with Commissioner Emer on this. If I heard him right, I feel like these we can allow personal and business services and office uses as a primary permitted use in all three of these zones.
Okay.
I don't think we need conditional use permits. I mean, so, okay, maybe if, because of some of these, I don't know. I mean, I would be open to hearing what other people had to say about it. But I guess what I'm wondering is if we didn't want to just simply allow it as a primary permitted use outright, maybe as a limited use or something where there's constraints on floor area or something like that. Because I guess we don't want like a big massive building that is a salon, right? In the R3, we want, kind of like a smaller neighborhood shop. So I don't know how we might approach that other than there just isn't a lot of opportunity, with existing development patterns for large scale redevelopment of, a neighborhood area into a massive retail salon. But, so maybe we just allow, the simple physics themselves to govern, to provide the constraints. But that would be my question is, is there concern about maybe getting one of these uses that's too big? And is there a way to handle it other than the conditional use review? Or do we just simply say, hey, these are all kind of multi-unit districts and, it makes sense where these things are already allowed as conditional uses to allow them as, primary permitted use, which I think I would support at this point.
Chair, if I may. So let me address the staff and let me go back and again hear the rationale for these being conditional uses.
Well, that's how, well, the easy answer is that's how it is in the existing code.
Okay.
I think the way I think the code has been set up is that sort of the R1B is sort of that first step outside the downtown, right? And so it has some limited commercial things and residential, and it's sort of this broker between the downtown and now our residential zones, which are still our high density residential zones. But I think that these previous iterations of the code wanted to allow commercial uses, but wanted them to be limited and require type 3 review to make sure that they didn't create impacts on surrounding neighbors. That's sort of that classic conditional use kind of review, right? Hours of operation, impacts on surrounding neighborhoods, compatibility with the surrounding neighborhood, those sorts of criteria. That's sort of the review that we would be putting one of those proposals under. And so I just think generally there was a lot of hesitation in wanting to allow for a lot of commercial stuff in those higher density zones. I mean, I'm guessing it's been like that for a long time. So that's generally what I'm thinking.
That's helpful.
Yeah.
Thank you.
Yeah.
Maybe just sharing a few thoughts, I guess, in the reaction, in the idea of, thinking about allowing it as a permitted use kind of in the R3, R2, and R1B. The one thing I'm kind of thinking of and looking at the zoning map right in front of me is how this would balance against trying to also promote development in places like the NMU. And, are you essentially kind of undermining some of the NMU? And so maybe that is a place where, to Commissioner Edge's comment, maybe thinking about it more as a limited use. So that's just kind of one thought and reaction. Another separate topic is just want to make sure we continue to not forget about it, but I think the map and thinking about the map at a parcel level and changes to the map is another thing I want to make sure that we don't lose sight of. But those, I think, are some of my thoughts kind of relevant to this topic specifically.
Right. So my guess, by looking at this map, right, the R1, B, the R2, and the R3 were meant as buffer zones to the residential neighborhoods, knowing the thinking back in 1990. So I didn't think about, I think lot size is going to restrain almost anything. And because you still have to live by the vegetation rules and the whole 9 yards, right? And by height. So really you can only get 2.5 stories or whatever, right? By height, and only 75% of the building can be on the lot, right? Take up the lot, or 67%. But I do like the idea of maybe even a floor ratio so that it kind of sets in stone, that it recognizes that it's maybe a height limit. Maybe you just say, 2.5 stories or whatever the single family dwelling height is.
It's 35 feet.
35 feet.
Yeah.
And, limited to 35 feet and, no more than 2,000 square feet. I mean, you can't get more than that on any lot in Milwaukee, even if you have a 10,000 square footer, base-wise, right?
We have limited uses in the downtown, for example, like square footage for certain things, 5,000 square feet for certain uses, 20,000 for others. It's a different scale, to be fair. So maybe what we might think about is kind of what is that sweet spot in one of these kinds, in a high density zone, if the notion or sort of the direction from the commission is thinking about, rather than have them be allowed outright, that they would be a limited use. And
yeah,
we need
it's
to
allowed outright.
It's allowed outright, but with limitations on the size. And maybe what we can do is come up with, that would be a key question as part of our planning, as part of the public hearing on the 27th. Is this the right number?
My initial reaction is that we should recognize that these are meant to be buffer zones, at least for looks wise, going into the single family housing, I think is the purpose of it. And I think that's not a bad tradition maybe to carry on. I don't know. I also, right, I'm also, let's redo this map because this is ridiculous the way that it's laid out. But I don't know. I get it. And
I'm trying to get us to where we consolidate all three of these new proposed zones, Greg.
Well, I mean, basically.
Yeah. We just end up with an RHD.
Well, it should be, R1 should be down King Road and down 32nd. And I mean, it's ridiculous how they're spread out like this.
Well, we are going to have another bite at this apple, just so you know. I think when we go in and we do both the housing work, we're doing the housing capacity analysis, and part of that will be understanding what's allowed in different zones, I think. And then also as part of the neighborhood hubs work we're going to be doing. So right now we're kind of getting it cleaned up and primed and ready to look at a little bit more deeply at another level.
Right, and I'm trying to think of, actually, the neighborhood hubs actually popped into my head when we were talking about this because, the idea of a neighborhood hub is basically take a small version of a downtown building, retail on the bottom, and a little bit of residential on top, right, and maximize that out. Well, if we're going to make a hair salon or whatever in an R3 where a neighborhood hub probably would exist, then you're just going to end up, right? Then every person that's going to try to lease that out has to come in and get a permit or get a conditional use.
We're going to look at we'll look at all of the zones and what language is around them and how we might think about consolidating or changing them again. But this is kind of like the first swipe at it as based on the idea of consolidating them and getting the language right regarding the residential care facilities and all of that.
Right.
It's iterative. I mean, we're doing these in pieces. It's going to feel like we're redoing stuff multiple times, but it sort of needs to kind of start in one spot and then we'll see where we are with the next phase, I think, of it.
But I do think, to your point, I mean, the conditional use process it adds a barrier to people doing this kind of thing. And I think that the city of Milwaukee has a lot of residential and not a lot of commercial. And so making people jump through extra hoops to kind of open up some doors, that's just it's a policy question.
Right, and I'm sorry.
Oh, I was just going to say, and I think to that point, maybe I'll pick up something I think Commissioner Edge was putting down was, thinking about single detached dwellings in R1B, R2, R3, should those be permitted outright? Or do we want to create a little bit of a barrier there to try and change the development pattern? So for example, R1B, do we want to say that a single detached dwelling should be a conditional use? Because as we're thinking about that buffer, maybe it is a single dwelling now, but maybe 10 years, 20 years, 40 years from now, that should be at a little bit of a higher intensity. And so we want to create a zoning code that helps us get to that. I think that would be a conversation worth having.
And just so, if the commission decides that they want to have that conversation now, great. But I also, just so you know, Commissioner Sherman, that we will have that conversation as part of the housing capacity analysis and our housing production strategy, because we have to look at all of our zones and trying to remove barriers, and also looking at higher density. And we have some of the lowest, our high density residential is very, very low compared to most of the region. So we still are, it's at a pretty low level. So we might need to look at that a little bit more in depth to see if we are trying to get some more of those higher residential uses so that we can provide more housing that is desperately needed.
Yeah.
Yeah, I think if I can, as I like the idea of getting into some of these, broader, conversations. I think that with respect to the single detached dwellings, although I think it's a good idea for those to not be allowed outright in the high density zone, I think that what we should try to focus on is just, like what we're doing is we're just consolidating these. We're trying to make sure that the uses that are already allowed are still allowed, and that we're just kind of getting it right and bringing. I mean, we're pretty close to alignment across all three of these zones for most of these uses. There's just a few things that are different, but I think what we could do is, instead of conditional uses for these specific things, these smaller commercial things that we're talking about, we could do those as a limited use where there's just like some kind of a floor area limitation or something. Because again, the height applies, the lot coverage applies. These are small lots. It's not going to be a massive, tear down and redevelopment of, something big. But we could still have the limited use, in place so that it's clear that, you're not going to have a massive retail salon in a neighborhood. But ultimately what we are looking at here is we are talking about the buffers where, the downtown is more intense, the neighborhood mixed use areas are a little bit more intense. And these, help transition from those more intense areas to our, pretty much, our exclusively residential neighborhoods. And part of a transition is, a transition, there's a mixture of things going on in these buffer zones, and they are at a less intense, scale and nature than what's going on in the NNU or the DNU. So, I feel like we could, just allow it, as like I said, again, not the conditional use, but a limited use where you just slap a maximum floor area on a use and otherwise say it's permitted. And then that's kind of what this process helps us do, is get, really, really, really close to alignment on these three zones so that we can have a really nuanced conversation the next time we revisit this about what do we tune, and maybe do we consolidate these even more into just an RHD, which I would be very fond of doing. But I realize we're not there yet. So without getting too far ahead of ourselves, I'm pretty comfortable with this if we leave the single detached dwelling conversation for another day. But then, just kind of figure out how to get the language right around that limited use definition for these commercial uses in these buffer neighborhoods.
And Chair, if I may, I'm just going to add one more thing onto this. I think eliminating the conditional use for the personal business services in R3 and R2, I think it works to the vision of more walkable and livable communities because it allows you some more personal services. And two, I think it strives to sustainability as well, because a lot of these, I think, maybe live what we call live work units, where somebody may have a salon in the front and they live in the back. And then that way that eliminates that worker from having to drive someplace or rent another place or take the bus somewhere or whatever. And so I think it is a win-win, and by permitting it outright, it certainly matches our vision.
If I could, through the chair, can I just confirm that the commission is generally on board with the additional switch here of allowing multi-unit developments by right in the R3 zone? Because right now they are conditional uses in the R3, but through the consolidation, we would propose that they would be allowed by right, as well as the residential care facilities. So those are two other uses that are highlighted in, the P is highlighted in yellow, because we're reducing the land use review in the R3 zone for those two uses. And I didn't want to leave this slide without kind of confirming or understanding if there is any concern from members of the commission about that.
Multi-unit is 5 or more?
Correct, yeah.
Is there a limitation?
it has to do with the density in the zone, setbacks, all of those
So
other things.
how big you can get a
That's right, yeah.
property?
Yeah,
Okay.
Yeah, I can support this.
okay,
Permitted in R3, both of those cases.
okay. Okay,
Yep, Vera, I'm also in support of what's being shown.
Yeah, me too. I think it's reflective of what we already see in the R3 zone.
I have no objection.
great. Thanks, everyone.
I'm also supportive. I do have a clarifying question, though. On the first table, table 1, hotel or motel, R1B is highlighted, conditional use. And then in the new table, table 2, it still is listed as conditional use, but it's not highlighted. I don't know if there's any rhyme or reason or if that was just a simple oversight, but
Yep.
it caught my eye.
Yeah, no, the table 1 was highlighted where were there key differences
Okay.
amongst the 5, but then in the consolidation, I didn't highlight it because I didn't change it.
Great.
It's
Yeah,
still
thank you.
conditional use, yeah. I got a little fast and loose with the highlight, I think, and I didn't make it clear.
Gotcha.
Sorry about that. Okay,
I mean, not to open another can of worms, but I would totally support making that a conditional use or even a limited use in all 3 of these zones as well.
Which one?
In
hotel motel?
R3, R2, not allowed.
Yeah, that's correct.
So I think what happens is that the vision of a hotel or motel is a large complex, which would still be restricted by size anyways, and probably would not ever exist in all truth. But your bed and breakfast or vacation rentals certainly could exist in those areas. I'm not even sure if it would actually fit in an R1B. It's got to be pretty close, but I don't care if it's a conditional use or not. If you want to make a hotel, I think that the realms of possibility is 0. To make it,
Yeah, I mean, you'd be looking at a boutique hotel, which could be kind of neat. Yeah, I mean, it's not going to be a large, like Hilton or something. I guess I was looking over all these commercial uses, and I really feel like I'm comfortable with all of these in the buffer area, and that we're talking about. I think that again, the geometry constrains what can be built. We've got the height, modest height standards, modest lot coverage standards. I think that takes care of everything that would be concerned about reviewing in a conditional use review. And so I'd totally be cool with all 4 of these commercial uses being allowed in all 3 of these zones. I think it'd be a great use of that space to allow these and allow, I mean, you're not talking about, massive redevelopment where so many of these things go in there. It's not going to be this big change. It's going to be this modest change where things will pop in over time and they'll be useful for the community around them. So I'd really like to see these commercial uses allowed in the multifamily zones.
so I want to be clear. So office, you want to see that as a PP instead of a CU, right?
Well, I think that we were talking about having a limited use so that we just make sure we're clear about, the amount of floor area that you have, right?
Right.
But I think that, yeah, fees across the board.
I would be fine with that. The hotel motel, I would, and the bed and breakfast or vacation rental, I think should be CU, conditional use, just because of the fact that vacation rentals, we do have kind of a stricter rule for them, and that if they exist outright without anybody knowing it, then we may not be able to collect business taxes on them, or they don't pay their hotel taxes, or those kind of things that they're supposed to be doing. So I think it's a nice little check on those just to make sure. I know that's
Do
usually,
you break apart bed and breakfast from a vacation rental?
no, because I
keep
don't
them the
know what the
same?
difference is anymore. I mean, really, what is the bed and breakfast? Well, it's, it's pretty much a,
Well, a meal has to be served in the morning. And I guess the operator has to be on site.
yeah, but if I had, I don't know. I mean, I guess if I were to run a vacation home out of my house and up there in Linwood, who nobody would ever want to go vacation there. But I mean, I would probably serve somebody breakfast. I mean, does that make me a VRO or a VBO or whatever they do? Or?
If you guarantee it, if it's included in the package, if what you're selling is lodging that includes a meal in the morning, that meets the criteria for bed and breakfast, at least in the county. They distinguish between that. That's how they distinguish it.
I think the criteria, probably one of the more operational things isn't necessarily, I mean, while the food does matter, I think vacation rental is rented for more than 270 days. Or not occupied for, not occupied for more than or less than 270 or whatever. So that I think is probably the thing. I guess that would be worth kind of clarifying, and maybe since this work session, you could help clarify it next time we meet. Like, if it wasn't a conditional use, would the city be able to make sure it was effectively collecting the tax revenue for lodging taxes and those kinds of
I think
things?
they would be able to because it's based on business permits, as I understand it. So it's really outside of the land use process.
Yeah.
So it's collected through business, licenses.
Yeah.
So the land use process doesn't have an impact on it.
I understand that. But then since it's a conditional use, they have to walk in, right? Because they need to get inspected anyways because they have to, the fire alarm thing, right? I think that was one of the deals, or they need to be inspected for safety.
Yes.
I just think it's kind of it's a terrible thing to say, well, let's use land use to make sure we get them. I hate that philosophy, but it seems like a very safe way because then if somebody has to come in and talk to somebody, they can be reminded of those facts.
There are other processes, though, that the city requires, like business licensing, right?
Mm-hmm.
Oh, right.
That you could capture.
Right, but the difference is that, let's say I ran a vacation home out of my house. And I never told anybody. Well, the only way to get kind of ratted out is by your neighbors, saying something to somebody, and then it's probably really hard to prove.
No, because code enforcement finds your listing online, and that's how.
Oh, looks at the listing on the.
We process them all the time.
You'd rather get them up front, I think, but.
Sure, but.
I don't know. I'll quit talking about it, and we can talk about it next time.
Staff will come back with a proposal for the hearing, and we can talk about it then. So, okay.
So I just want to be clear. So the idea is that right now it's still a conditional use for the bed and breakfast across the board. And then the hotel and motel, I think I heard Commissioner Edge saying that he wanted to move away from the not permitted in the R3 and the R2 and potentially go to a CU or permitted. So I just want to get clarity that you all agree with that proposal and what exactly you're proposing, Commissioner Edge.
I thought I heard conditional.
That is you did hear that correctly from me. I do want these to be permitted in all, the hotel and motel will be permitted in all three zones.
And bed and breakfast and vacation rental, correct?
Yeah, I think so too. I think that those would be fine too. Those should be two separate discussions.
Right.
But I think that I would like to see P's in all of these cells.
Right,
yeah,
and
across
office.
all rows, all columns.
Right, and office too.
Yes, yeah, all four commercial uses that are listed in all three zones, I would be comfortable with permitted, primary permitted use for all of these.
I certainly agree in principle. I have a little bit of holdback on the bed and breakfast and vacation rental.
Fair. I think Scott can come back with some ideas, for us to chew on with that. And Does that sound okay, or do you want us to kind of hammer this out right now?
No, we can certainly come back. Or as part of the public hearing, we can talk.
Yeah.
I think the only thing that I would say about about the bed and breakfast or vacation rental piece of it, we only have, I think, 3 vacation rentals in the city right now, because there's a conditional use review process. But it seems to me that folks that live in a neighborhood and think that there's a single unit home next to them and know that folks are cycling in and out as a vacation rental without folks knowing about that seems to give some neighbors pause. I guess that's all. I'm not defending it one way or the other, but we do hear from folks when they know that there are lots of people, because there isn't any, no one lives in the house. It's only for folks renting it for weekends and that kind of thing. And I think, we've heard from.
I mean, it's essentially a commercial operation. It's like a hotel room.
That's right.
It's like a standalone hotel room. And so I almost want to regulate it like a hotel room. And not like a bed and breakfast. But maybe a bed and breakfast is just, I don't know, it's just a variation of the same thing. Bed and breakfast, is different. You're in a bedroom versus a whole house.
Right.
You know what I mean? I feel like those are 2 distinct things. And a vacation rental is much more closely aligned with a hotel or motel.
Not necessarily true, by the way, Vice Chair Edge. They do rent out entire spaces.
Bed and breakfast?
Yeah.
And if I could just clarify, I think that you were saying that you wanted the hotel and motels permitted as well. So.
Yeah. Yes.
So either they're all permitted, or what's the difference between the hotel and motel being permitted and a bed and breakfast being a conditional use? And it seems like a hotel motel would have higher impacts than a vacation rental. So.
So I think a place to start with that I certainly feel comfortable with is for hotel or motel, R3, R2, turning it from a no to a conditional use. I think that makes sense. I think the next step in the question of are we turning some of these CUs into Ps, it might warrant additional conversation. I do think, as somebody who just spent a lot of time in short-term vacation rentals, I think there is functionally not much of a difference between a vacation rental and a hotel or a motel, right? We're probably talking more than anything about the size of the structure, but from the impact aside from the size of the structure, the impact to the neighbors or the other residents or adjacent property owners is pretty similar. Lots of people coming and going. So, it might even warrant thinking about vacation rental carving off into its own category separate from bed and breakfast, because I do think there might be a little bit of distinction there, but maybe we're getting way too deep into the weeds on this as well. So
We do.
Yeah.
This is definitely my comfort zone in terms of depth in the weeds. I think that I personally would like to see those split up. B&B is separate from a vacation rental. I'm interested in hearing more, what others think about, making those, primary permitted uses versus conditional uses. I think that definitely at a minimum, we switch hotel or motel from no to conditional use at the very least. I think that's an incremental improvement. I would support that on its own. I would just prefer to take it that step further and allow all of these commercial uses. But that's just me, and we have to find something that we all agree on. So any amount of bringing this closer to permitted for all of these uses is going to make me happy, and I'll support wherever we end up with it, as long as it's allowing this, making it easier to allow these commercial uses. That I would be in support. So all the way up into seeing keys in all of the columns.
I would agree, Vice Chair Edge, but one caveat, I don't see the benefit, or I'm not understanding the benefit of separating out vacation rental from bed and breakfast. And I wonder if that overcomplicates this and unnecessarily so.
I mean, it could. It just depends on if we wanted to regulate them differently from each other. You know, if there was some compelling reason to regulate bed and breakfast in some different way from vacation rentals, then, you know, like if you still wanted bed and breakfast to be a conditional use, but you wanted the vacation rental to be primary, like a hotel or motel, and make those primaries as well, that'd probably be okay, you know, but, or the vice versa. You know what I mean? It just depends on if we felt really strongly that one of these things needed to be regulated differently than the others. And I'm just kind of thinking about in terms of what gets used already and what we're seeing. Like just, you know, in the RNB, what we see home occupation permits for, or like, you know, bed and breakfast and things like that. And then the vacation rentals are, you know, like you said, there was only 3 of them because they're conditional uses, but.
I would think that I would lean towards making those into Ps. Bed and breakfast, keeping bed and breakfast and vacation rental together and making it a P under every zone.
I'd support that.
I mean, Vera, you said we have what, 3? I'm not in fear of this, like overrunning any of our zones or doing anything that would negatively impact our neighbors and our community. I think, and I think actually the reverse, it provides greater diversity within our neighborhoods. And I think it's actually a benefit. So I would support moving towards P, permit.
Okay.
All right.
Chair, may I ask a clarifying question real quick? Does a conditional use require notification within 300 feet?
It's a type 3, it's a decision by the planning commission. So yes. Yeah.
Yeah, so I mean, I think some of the problems with these vacation rentals is that the neighbors don't know that they're there and that there are issues with the vacation rentals. Like if somebody throws a big party, who do you call? And so we put in that, you know, somebody has to have the manager's telephone number or something like that. And that's why I like keeping it a conditional use, because at least it notifies, you know, that's something.
That's a pretty big hurdle, right, Greg, to ask somebody to go through the process just for that? I mean, I think the concern you raise is legitimate, but is there another way? Because
I think that those things are profitable enough that if you really want to do it and you see the dollar signs in it, that a $3,000 bill to come and to talk to the planning commission is certainly well within that business model. I don't think giving somebody a long-term haircut and the cost of the rental space is probably worth $3,000, but I certainly think that a vacation rental is. In fact, you're probably going to end up spending a lot more on insurance in the first 6 months for that than you are going to the planning commission.
Hey, Chair.
I have a question for staff about this.
Can we?
Sorry, go ahead.
Commissioner Macy was.
Yeah, I understand, you know, the point that the chair makes about keeping the bed and breakfast, you know, combined. But to my point of view, I think that a bed and breakfast, you know, is operated much like a hotel or a motel. In other words, the neighbors would know that it's, you know, it's an operation in being. And I think a vacation rental, whether it's, you know, an Airbnb or a VRBO or whatever, you don't know that, and you don't know the extent to which it's being used for commercial purposes. And I will, you know, I'm inclined to say, yeah, let's go P for that. But then I think to myself, well, we have 3 now, but if it all becomes a P, how many will we have? You know, so it's going to be easier to convert that. So I'm just concerned about possible unintended consequences here, and that's why I don't think we need to make a decision tonight. But these are just thought pieces on my part.
I think we should be really clear about how we define those two things, bed and breakfast and vacation rental, because I would like to see how we define them.
I agree with Commissioner Massey and what he was saying about unintended consequences. I feel like I've recently seen a number of what I probably never knew before were rentals now on the market to be sold, and, you know, seeing probably our neighbors moving out of the city. And, you know, while there might only be 3 vacation rentals that the city's aware of, I, you know, would imagine there's probably some other ones out there. And I do think it could open the door to a business model that is pretty profitable, which is why, you know, many people, you know, around the country are doing this and investors are getting involved in that. I would have some concerns as well on the vacation rental specifically.
I kind of want to reset our conversation a little bit because we're only talking about R1B, R2, and R3. We're not talking about RHG or RMD, you know, which is the bulk of the land where single detached dwellings are. You know, we're not changing anything there. We're only talking about these smaller zones. So with that in mind, the staff, are you able to easily answer the question, how many detached single dwelling structures are there in these 3 zones in the city?
Yes, but not tonight. I need the GIS layer because it'll tell me what the land use is for all of those properties. So I can certainly come back with that information. I can't do it today.
Yeah, so, you know, we're talking about zones where there's a lot of other uses already. There's already some, you know, multi-unit. There's already some institutional or assisted living, you know, approved. You know, there's different things going on in these zones already. They're not all just, you know, single detached houses that are, you know, possibly, you know, ripe for VRBO or whatever. So I don't share the same concerns when we're talking about this limited geographic area. I think that it would work out okay, and that the unintended consequences would not be as impactful as if, say, we were talking about the RMD zone, which I would have serious concerns about opening up to vacation rentals beyond a conditional use permit. That I think should stay for sure in the RMD. But in these 3 zones, I'm totally cool with limited scope and limited geography here. I'd be fine with making it permitted.
Okay, on that note, I think I'm going to ask Vera that we continue and move forward. I think we've gotten plenty of feedback on this.
Yep, sure did. Thank you. Speaking of those limited zones, here they are again on the map. And again, this reflects the proposed combination of zones. So you can see it's not a lot of area, but just so you would understand kind of how they get glued together and what we're talking about. Okay. Final couple of slides just have to do with the development standards for these zones. So you can see in the existing code, R3 and R2.5 are basically close to the same when it comes to height and lot coverage and vegetation. The density is a little bit different. The R2.5 is just a skosh higher density. The R2, R1 and R1B, we get extra height there, so we're up to 45 feet. Little bit of extra lot coverage, quite a bit less vegetation, so we're down to 15%. So that's the way our existing code is set up. The proposed consolidation basically sort of bumps things up. So the R3 is the same for the height, lot coverage, and vegetation. But it uses the R2.5 density. So there's a slight increase in the maximum density allowed in the new R3 zone. R2 and R1B are basically the same. They're sort of intact. The R2 pulls from the R1, in particular the density piece. So areas that are currently zoned R2 would have a bump in density, both minimum and maximum density. And I think what we're trying to sort of reconcile here is that these are our high density zones, and particular because in the moderate density zones, as we remember, I think from our middle housing discussion, middle housing types don't have a maximum density. So what we're trying to do is get a density range that is more consistent with the intent of our high density zones, which is higher density development. And what this also does, and what we've been hearing from folks that have existing multi-unit developments, and they're older ones from the 50s and the 60s, that under our current code, they can't add any units into their existing developments. So it's not sort of new apartment complexes that we're hearing from. It's folks that could, put in an extra studio apartment or something in an existing development, and they can't because they run up against that density, that maximum density. So this is a pretty significant change. So we wanted to understand what the feelings were from the commission about how the consolidation deals with density as well as some of these development standards. And if I could, I'm going to come back to this slide in a second, but associated with the density, and this was in the staff report, the code currently has this minimum site size limitation in the R2, R1, and the R1B. So it establishes right out of the gate what size your site can be on top of the density. So it's this added, it's really a belt and suspenders for density in a way that we think probably unintentionally maybe discourages development of multifamily housing because it's setting a floor, a pretty high floor for what size your site can be, rather than relying solely on density, which is what all the other zones do. We talk about density only, but I honestly don't know the rationale behind trying to, besides sort of limiting density, frankly, in these zones, that sets this floor for site size. So what we would like to recommend is that we rely solely on the density standards and take the minimum site size standard out of the code, so that it's applied, so that density is applied consistently in the various zones and not sort of singling these ones out. But so I'll kind of go back to this, but the two are related as far as how these development standards get handled as part of the consolidation. And in case anybody's wondering, this is the end of this. So we can sort of go from Airbnbs to densities and standards and land here. But this is a question I would really appreciate. I would really like direction from to understand if the commission's comfortable with this part of the consolidation proposal.
Chair Losfeld, if I may.
Yes.
I was actually going to ask our newest commissioner, Commissioner Freeman, if he had any thoughts on this. You've probably realized, Josh, we're a talkative bunch and it might take a moment to get in edgewise. So wanted to give you an opportunity to come out of the gate on this.
Thank you, Commissioner Sherman. I'm learning a lot from the dialogue here. It's nice to hear the back and forth. I don't think I'm in favor with increasing the density here. I think that's kind of what we're supposed to be going towards, right? With the increase with the middle housing and stuff like that, and trying to get more, more spaces for people to live.
We asked Commissioner Freeman.
Yeah, thanks for sharing that, Commissioner Freeman. Appreciate hearing your contributions tonight. And welcome to the group. And it's nice to have you here. Did have a comment about this as well. Is this my turn?
Go ahead, Vice Chair Edge. It's your turn.
They're very, lots of confidence there.
So, I know how this is going to sound. Even the county allows 60 units an acre in their high density zones. Even the county. And that's a recent change. It was 25, don't get me wrong. They weren't far off from what we've got here. But they went through a housing strategies process where there was a lot of input, a lot of public process, and in their what they call their residential high density zones, which historically were 25 units an acre max. They're now 60 units an acre max, and that's what it kind of had to be in order for these projects to pencil out. You've got to get kind of into that range where you have 45 to 60 per acre range to start achieving profitability. And so I think we need to go higher. I think you need to look at 60 units an acre or better.
That was 5-0. I just want to make sure I heard you.
6-0.
Thank you.
If I could insert a staff perspective here for a second, and I don't disagree with this notion of trying to revisit these densities. However, at this stage, we don't have the housing production strategy. We don't have those metrics and that report ready. I think the report's going to be telling us that we probably need to address our densities. So one way of thinking, and I don't mean to punt, but I guess I am a little bit, as a way of talking about this and increasing densities like this, that we might want to have those reports and that study information in our back pocket to help us tell this story of increasing the density that much. Again, I think we need to be there, but the numbers may help us, and I'm happy to have Laura chime in there. But
this is just an interim step to try to get it better in alignment.
Right.
We're doing the consolidation.
Right, but that doesn't mean we shouldn't be.
Yeah, so I want to say I fully agree with that. I think that we do need to have the supporting data. We need to have we need to have facts to put findings on before we make changes. I think that obviously makes a ton of sense. I just wanted to make sure that I clearly signaled where my comfort zone is here.
Could I ask a question? What is the timeline for those studies to be delivered?
We will have a draft of the housing capacity analysis. That comes to you, I believe, in November. And then the housing production strategy, I believe we come to you in maybe January.
Okay.
So we are on a quick timeline for that.
Yeah, that's.
And then as a follow-up clarification, what sort of public notification, if any, do we need to do to property owners? We consolidate these zones. We're changing the allowable intensity on properties, and do we have to notify people? And then if we come back in January when we get our study and we want to change the number to 60, do we have to go back and notify them again that things have changed? Can you help us understand what our requirements are there?
So the requirements through the Measure 56, legislation is you need to do direct notification when you are taking something away from someone. All of these proposals are giving people more opportunities, more density, more whatever it is. We're not making anything more difficult as part of this. So there is not a requirement for direct property owner notification. We would, as standard course, obviously do our notification for our the 30-day notice. We always notify all the NDAs of any code amendments like this. So we always do a direct email with all of the information and requests for questions and that sort of thing. But we have not done, we haven't done any direct landowner notification for this consolidation process, no.
So we could conceivably, though, run into Measure 56 issues if we increased the allowable intensity of use on some sites and then later came back looking at the map parcel by parcel and said, wait, this one doesn't make sense. Let's change it down.
Right.
That would then create a potential takings.
Yeah.
But in this area, it's such a small number of properties that it really impacts.
Okay.
And if we were going to propose talking about higher densities, we would have questions. We would do public outreach, like Vera said. We would talk about this through the housing production strategy more to get people's feedback on the new, there'd be a number of different strategies that we would be looking at for trying to increase housing production throughout the city. This would just be one of them. So we can talk to folks about it.
Thank you.
So, Josh, I'm here to help you out because I've been here for 7.5 years and I know everything. So I'm here to help you out. Can you explain what density, DU per acre really means? So if I have a 10,000 square foot lot, which is a quarter of an acre, does that mean that I can only do a quarter of 32?
Yes.
And that's how that, it's not everybody's property added up. It is a piece of the property and its relationship to acre and how many units you can have on it.
It's on a per site, per lot basis.
And density is considered a unit, not if I have a two apartment, if I have 4 2 apartments, that's still considered 4 density units, not 8.
That's 8.
So it does count.
Dwelling unit per acre, yeah, it's each individual unit, yes.
See, Josh, I'm just here to help you out, because. All right.
I appreciate that.
Vera, I just kind of thinking about what Vice Chair Edge had said. I'd feel like 25, like the numbers are low, but I don't know what's appropriately high or, and so I think that your report will start to inform that. But generally speaking, I guess I would be in favor of increasing that number, but I just don't quite understand context of what's appropriate.
And to Chair Loosfeld's question on the context of kind of what's appropriate, I mean, essentially we're creating like a weighted average here, right? As we're consolidating, we're just kind of weighting things. But you know, why did we get to R1B, you know, minimum and maximum 25 and 32 in the first place 10 years ago or 15 years ago? I also agree that it seems like these should be higher. You know, what's the correct number? I don't know, but.
If I may, through the chair, if it's, and I realize that we're going to be, you know, you're going to be seeing these numbers in a couple of times, but if as part of this consolidation, if it seems reasonable to, yeah, let's do this now. And because we're using density numbers that exist right now. We're just sort of applying them to a different part, to a different consolidated, you know, section of code. And then, you know, and I'm, you know, it's nice to hear that we are, you know, we're open to hearing about some higher densities or some higher numbers. Then we can use those, you know, the housing capacity and the housing production strategy to figure out what that math is. And to your point, Chair, you know, what's the right number? You know, that the housing production strategy will tell us what that right number is. And rather than trying to figure out what it is right now, maybe we, you know, we kind of wait for the math. But in the interim, we simplify the code, we consolidate the zones, and we apply the densities that we have now, because we have I mean, there it is. We didn't make these numbers up. We're doing this weighted average kind of scenarios Commissioner Sherman was talking about.
Chair, if I may, this is a question for the staff, and tell me if I've got this right or wrong. Would you characterize this as a conservative placeholder?
Yes.
Yes.
That's kind of what it appears to me.
Yeah.
Yes.
Okay.
Agreed.
Thank you.
Yep.
I would be in support, Vera, just for this simple process of clarification and kind of knowing that down the road we will have a further conversation about what's appropriate. If we agree on that tonight, in order to kind of help steer this conversation, that it makes sense to consolidate or to have consistency, I would say it does.
Great. Okay. And if I may infer from the direction of all this conversation that the commission is supportive of getting rid of the minimum site size standard? Or were everyone feeling okay about?
I would agree. Yes, that seems
Good. Okay.
Yeah, I don't even get what it means.
The barrier crossing.
Okay. So that's the end. Again, we'll be here on the 27th with the hearing, and you'll see all of this, and you'll see the actual code language. We'll all be part of it, and then we'll get going on this. So.
Thanks for all your great feedback.
Oh, this was terrific.
Yeah, really great.
Thank you very much, everyone. Really appreciate it.
Hey, Vera, I just, for the public hearing, how is the public being notified? Or, I mean, I'm wondering, it's obviously these are important conversations and would be great to have some more representation from our NDAs or from our community at large. I'm just curious how that's being communicated.
The 30-day notice is posted physically at the library, at City Hall, and the police station, and of course at Johnson Creek. And we'll be sending direct email to all of the NDA members with information about this whole package of code amendments, and asking them to please share with their membership about what we're proposing, that it's specifically for the high density zones, but we'll send them to everybody, of course, anyway. And we can certainly, and include the CPIC, because this was part of, that phase one of that implementation. So we'll be doing a lot of email blasts, and I'll be asking the city staff here at City Hall to get information out on our social media channels as well, so that folks are aware of what's happening and how to participate in the hearing as well. So that's what we were thinking about doing.
That sounds great. Chair. I'm glad to hear you're doing all that. Yep.
Chair, I think that this might be something that would actually fall within the CIAC, and I could tee the NDAs up when I meet with them in September that this is coming.
Great. I thought the same thing, Commissioner Massey, but if I understood that meeting date was the 29th, this is the 27th.
Yep.
No, sorry.
I mean, I originally had thought that your meeting date was the 16th for some reason.
That's what I thought too.
I thought it was too.
Right there with you. I thought it was in the middle of the month.
Okay. Well, I'm glad I'm not crazy, because I thought for sure that was the date. But okay. Yeah, I thought the same thing, but unfortunately it's after.
But the good news is that Vera will send out this information to the NDA so that they will have the information.
Yeah. Yep. Agreed. And, it'd be a great opportunity, Commissioner Massey, to hear if they have a response or if anybody was able to attend.
Or even if you go to your own NDA meetings or picnics, which Laura's favorite part we'll talk about, you as a planning commissioner can talk about it in general if people have clarifying questions, because it is complicated.
Yeah.
And as Commissioner Edge or Vice Chair Edge always likes, it's only a small part of town though. Just relax, everybody relax.
It's not fair. No picking on Commissioner Edge. Okay. I think we're going to move on, or I'm going to move us on. Watch me do that right now. Okay. Moving on. Just to be clear here, there's no okay. We're just going to cover other business. Sorry, I'm trying to make sure I hit all these points here. Are there any other items up for discussion?
I guess I had a clarifying question. Were you going to give any CIAC updates now, Laura?
I could just briefly. What I was thinking is that for October 11th, that was the original date that we had talked about having the joint planning commission and NDA meeting. I was thinking about also possibly having the annual CIAC meeting that night and inviting John Hennington, the city's equity manager, to come and talk about all of the equity work that the city is doing as meeting as a CIAC, kind of is like the foundation, is the baseline, kind of, it's kind of like an understanding of what the city is doing with that work. And then that way the NDAs could also hear what is going on with that work if they chose to stay for that portion of the meeting. So that was kind of what I would be proposing to you all to do on October 11th. We don't have to decide tonight. You can maybe mull it over. We can talk about it next time too, but that is kind of what the approach that I came up with, so that we are having a good dialogue around engagement because of your role as a CIAC and bringing John into that conversation.
I think that's a great idea.
Initially, that sounds like a good idea.
Yeah, I mean, the CIAC has the potential to have so many tentacles, and the more that we can kind of get the right people in the room to talk about these various things, the better. And so, yeah, I think it's a wonderful idea. It'll be an extended work session, I guess. Mm-hmm. Yeah. So don't bring any land use applications that night.
Yeah.
Try not to.
Do better than try.
Well, I was going to make a motion, since Adam is here, to extend the meeting so that we could actually get through that other little process that we had.
Not on my watch. Okay, forecast for future meetings.
Yeah, Chair Losfeld, can I, on the CIAC topic, one thing that I
thought we covered the CIAC like at the early part of the agenda.
No, it came up through the Milwaukie Bay, and I didn't feel like bringing it up at that time. I would really like it if we could, we give notice of applications to other governmental entities, Metro, ODOT, et cetera, et cetera, et cetera. I think it would be good practice, so especially around signature projects like Milwaukie Bay, if we gave formal notice to the tribes. And so I would encourage staff to think about that. And I know that city staff are liaising kind of with the tribes, but I just think it would be an interesting opportunity to kind of provide that formal mechanism to say, hey, we've got this going on in our community. You're an important stakeholder, and we'd like to hear from you, just as we do from a variety of other governmental agencies. So want to just kind of put that out there as for some to be kind of thought about.
Sounds like a great idea.
Other business, if I may.
We're capped out on other businesses at
the more you interrupt,
two other businesses.
Here we go.
Should I mute them? You want me to mute them?
What I want everybody to know is that the picnic season is coming on with your NDA. So I know that Island Station is doing theirs September 10th. Hector Campbell already did theirs on August 14th. Linwood is doing theirs September 3rd at Fernburg. Watch your neighborhoods, because this is a great time to get into the social atmosphere of connecting with your NDAs. Identify yourself as a planning commissioner, and try to get the work through the CIAC that way. Now, this one's for you, Lauren, though. So the Milwaukie Museum, Two Sisters Play Cafe, the Clackamas County Cultural Coalition, and Milwaukie Lumber, along with Professional Fools Productions, are proud to present performance at the museum September 10th with Juggle Mania, performing two shows, 1:30 and 3:30 p.m. It'll be on the back lawn of the Milwaukie Museum, located at 3737 Southeast Adams Street. Please bring a blanket or lawn chairs. Admission is free, but please feel free to tip the performer. And if you guys have kids or grandkids or children of all ages, it is a fun time. It's free. Come and join it. 1:30 and 3:30.
I can second that. We went to it last year. It was awesome. Although I am going to go online and search for Hemer's Haven as an illegal business. B&B. I'm
Josh is the only person that has rented the room, and he liked it so much he bought a house in Linwood. That's the whole deal. Right, Josh?
Kemers Haven. Okay, can we adjourn this meeting, please? Watch me do it. All right, I'll entertain a motion. Commissioner Freeman, would you like? Well, I gave the opportunity for forecast, I think, and got overrun by more new business.
I got five seconds. We have 2 hearing items on September 13th. We have 2 variances, and we have a work session item for the climate-friendly, equitable communities rulemaking that came down from the state. That's it.
Awesome. Good job, Laura. Commissioner Freeman, would you like to adjourn us by making a motion?
Sure, I'll make a motion that we adjourn the meeting for tonight.
All right. All in favor? Aye. So I seconded.
Aye.
Good night, everybody.
Good night. Good to see you again, Josh.
Aye.
Josh, I hope you come back.